Ghazi, Defendant. If we could have the parties identify themselves for the record.
Good morning, Your Honor. I'm Burke Johnson. I represent the plaintiff in the case, Gene Reynolds Realty, and this is Mr. Gene Reynolds. And this is my associate, Cullen Threlt, who's observing today.
All right, great, fantastic, welcome. And on behalf of the defendant.
Good morning, Your Honor. Jeff Deloach, and this is my client, Bobby Gazi or Bobby. You'll hear me refer to him as Bobby Gazi.
Yeah, Bobby Gazi. I go by Bobby.
Got it. All right. Thank you, Mr. Loach. Mr. Ghazi. All right, so we are here on ready for a bench trial on the case in chief. We've got the consolidated pretrial order, which I believe we already had that signed and entered as part of the record back in January. And I've also got receipt of 3 motions in limine filed by the plaintiff. The third, I think, of which has essentially been conceded as moot or granted without opposition, leading only the first 2. Other than those 2 motions in limine, are there any other kind of housekeeping pretrial matters we need to get into before we can get into maybe an overview opening statement if either of the parties want to make one, and then call them getting into the evidence? Mr. Johnson.
I think there's anything else, Your Honor.
I don't have anything, Your Honor.
Okay. All right. Well, as it relates to the motions in limine then, having reviewed both of the parties and the filings and the response, the first was seeking to exclude evidence of the commission, defendant countering that it's admissible for an intent, not necessarily as an offset for damages. Unless there's anything else plaintiff wants to add and kind of a reply. My thought there was, we'll see if intent actually does become relevant in some way. And my impression, if this is first, we're going to be looking at this strictly as an issue of contract. We would just be looking at the 4 corners and that sort of thing. But certainly don't see how this would ever be coming in as offsetting damages. But Mr. Johnson, if you want to, you rise. Sounds like you wanted to have some additional thoughts on that one.
Well, Your Honor, not. I was just going to rise to say no, Your Honor, not really specifically. And I guess, quite frankly, once you have a motion in limine that the court has already heard as the judge, it doesn't really quite have the same effect as a motion in limine to keep it out of the jury's ear. So I understand where the court is on that, I believe, and I'm fine with that.
Okay. Like I said, maybe there's a relevance objection as we see where the case leads us, but right now I would deny the plaintiff's motion limiting number 1, and if such evidence does come in, only give it the legal effect to which it is properly entitled. It's kind of a similar thing with number 2, talking about the title chain. I can certainly see why reference to it might be coming in to explain performance or intent of the parties, but I certainly wouldn't be taking that to be the last word on whether there was or was not, in fact, appropriate title. Anything else there, Mr. Johnson, you think you want to add? Okay. All right. So I would deny plaintiff's motion limine number 2 along those lines as well. And if there's nothing else, then I guess we can get right into it. So any kind of opening remarks on behalf of the plaintiff, giving me an expectation of the evidence and kind of the legal theory of recovery here?
Yes, Your Honor. Thank you, Your Honor, and may it please the court and counsel. Again, for the record, I am Burke Johnson. I represent the plaintiff in this case, Realty Incorporated. And again, with this being a bench trial rather than a jury trial, I probably won't be quite as elaborate on some things as I otherwise would have, because I know that the court is quite familiar with the case. But I will go through some of the basics that we believe the evidence will show. Again, we show this to be a breach of contract case. My client, Gene Reynolds Realty, is owned by Mr. Gene Reynolds here. He's the principal there. He is a real estate agent and broker, has been in the real estate business since the 1990s, or I think he got his real estate agency license maybe in '89 and his brokerage license and started his own brokerage in 1999. You'll hear from him on that. So he's been doing this for a long time. He had a listing agreement with the sellers of some property that's on Gay Road in Meriwether County. And the listing agreement really binds them as to the commission that he would receive as his his earnings, his salary for lack of a better term. In this case, that's how real estate agents are primarily compensated, is through commission. Bobby Gazi, the defendant here, contacted Mr. Reynolds, wanted to buy some property in the area down in Meriwether County. He has a friend down in that area who he wanted to buy some property close to. He and his wife live here in Atlanta, but I believe we're looking for a sort of country place out in Meriwether County. The evidence will show really that Mr. Gazi is a very sophisticated real estate investor. He's done this a lot. He has multiple corporate entities set up. He's got an engineering degree from Georgia Tech. So he's a very sophisticated and intelligent man and knew what he was doing here. He's not somebody who just was buying their first house and didn't have a clue really what was happening here. Ultimately, again, they settled on buying a property at 6550 Gay Road in Meriwether County. He and his then girlfriend, Sarah Stewart, who's now Sarah Ghazi, they've been married since this all transpired, went down to the property several times. She took a girlfriend with her down there to see the property, took her father down to see the property. They really liked it, and they made an offer. There was a binding contract as of September 5th, 2021. The binding contract agreement was $485,000. It was supposed to be a cash sale. It was supposed to close by October 15th of 2021. The contract provided that Mr. Ghazi would provide a $10,000 earnest money payment. I know the court knows what that is, and he did in fact wire $10,000 earnest money to Mr. Ghazi, to Mr. Reynolds' trust account for the earnest money. In this case, again, we're seeking the money that Mr. Reynolds would have earned on the sale had it gone through. The 7% on the sales price of $485,000 would be $33,950. He's also seeking his attorney's fees under the contract, which does provide the prevailing party, will receive their fees. And again, Your Honor, I believe that honestly, most of the facts here are really not in dispute as to what happened after the contract was entered into. There was the closing date that was specified. Mr. Ghazi hired a law firm to represent him. Again, he's a sophisticated real estate investor. He's used the same firm before, so he had his own lawyer who ran title, did all the things that one would normally expect a lawyer to do in connection with a closing. And he well knew that he had a closing date coming up on October 15th. Around October the 12th, 3 days before the scheduled closing, Mrs. Ghazi, on his behalf, sent some texts to Gene Reynolds saying that he, Mr. Ghazi, could not get the cash together for the sale, essentially, and that he needed an extension of time to get the money together and wanted a 30-day extension of time beyond the October 15th closing deadline. And here's where things kind of went wrong, I believe, Your Honor. Up until that point, again, I think all the facts are undisputed. Mr. Ghazi, as I said before, previously had wired the money to Mr. Reynolds, understanding full well the import of that and the understanding that it really needed to be there in a timely fashion and how significant and important earnest money was to the binding nature of the contract. Well, here he didn't wire the money. He claims that he sent a check. The check was never cashed or received or deposited by Mr. Reynolds. Mr. Ghazi never followed up on the earnest money check. He never contacted Mr. Reynolds to see if it was received. At the time of his deposition earlier in this case, he testified that it never cleared his bank. Obviously, we had done discovery throughout the course of the case, asking for all documents that would be relevant and pertinent to this. And only yesterday afternoon did we get a check stub purportedly prepared back in 2021 that shows that he wrote a check for $10,000. I believe the evidence will show that's a little circumspect at this point to have not had that up until the day before the trial starts. Ultimately, though, the money was never received. And so it's our position, the plaintiff's position, that there was no binding contract after October 15th. The initial contract expired because of the failure to provide that additional $10,000 in earnest money. What really gets interesting then is a few days after that, apparently still believing somehow that he had a contract, Mr. Ghazi sends a message to Mr. Reynolds, and I'll leave some of the colorful language out. The colorful language is in the texts. But early one morning, Miss Sarah Gazi, his wife, sent a text to him saying, "What the F, Bobby? I didn't know there was a gun range near this property." Essentially saying, "I don't want to raise our children there. I don't want to have anything to do with this property. You've got to apologize to Gene and back out." Shortly after that, Mr. Gazi sends a message to Mr. Reynolds and says, "Gene, Sarah is pissed at me. We've got to back out and forfeit the earnest money." Breached the contract at that point. If there wasn't, we've got several stages here. We believe the original contract that expired as of October 15th wasn't in effect after that date. If it was, in his position, if it was, then he breached it prior to the second closing date or the extended closing date by telling Gene, "We're walking away, we're forfeiting the earnest money." So that's an anticipatory breach of that contract. Only after that, then, if you remember, that they had the closing attorney. In fact, Your Honor, the evidence will show that his closing attorney not only offered, but sent him closing documents while he was in Italy for a mail-away closing, which would lead one to believe that everything was in order. There were no issues with title. Mr. Gazi didn't sign it, didn't get it back to them from Italy. And it was only after all this sort of came about that he then hired a new closing attorney who was hired and who ultimately found what they believe are 3 title exceptions that would have given him a right to get out of the contract or have the contract renegotiated or something like that. We believe the evidence will show, Your Honor, that those objections, as they're called, are nothing significant, and practically they're nothing more than pretextual. Pretextual for trying to find an excuse to get out of the contract. Again, Mr. Gazi had his own lawyer. The knowledge of the lawyer, we believe the evidence will show the knowledge of the lawyer, the law will show, is attributable to the client. And so they knew all about the title on this property well before this. And again, we believe the evidence will be that was just a pretextual effort to get out of the contract. So again, Your Honor, the breach of contract, we're going to be asking the court for the $33,500. I believe it is $33,000 plus attorney's fees that I will testify to as we get to that point, Your Honor.
Just 2 quick follow-ups for you. I just want to confirm the bad faith claim and attorney's fees. Can you just confirm the statutory provision? Is that the 13,611?
Your Honor, I think we should just withdraw the bad faith claim. I think it's really just under the contract. So I'm not going to go on the bad faith aspect of it. I'm just going to go on the breach of contract and what the contract provides for.
All right. So we'll consider count 2 withdrawn.
Yes, Your Honor.
And then I just want to be clear here as well. I know so many of these contractual analyses, it's an if this, then that, and this, then that, and different paths diverge. What is it that you would contend are the factual findings I need to make today? Because if this is purely, most of these facts are undisputed and it's just, legal application to these facts. I guess in the back of my mind, I was wondering how we didn't do this in a motion for summary judgment phase, but.
Well, I think there are maybe some factual disputes. I think the biggest factual dispute is going to be whether or not Mr. Gazi, you believe that he actually ever sent the $10,000. Okay. I think that's probably a factual dispute. Again, it's our position that it was never received. He never followed up on it, and check has never cleared his account, at least as of the time of his deposition. That's what his testimony was. So I think that would be a factual dispute as to whether or not the consideration for the second or for the amendment was ever paid.
Okay. Anything else along those lines?
I suppose if we get into it, then there may be a factual issue as to whether the alleged title issues that were raised are in fact sufficient to show a breach of the contract by the sellers, really, for not being able to provide a good and clear title. We will show evidence. We will have evidence, Your Honor, that shortly after this fell through, that Mr. Reynolds brokered a deal with some other buyers just a couple of months down the road. That deal went through, same contract price, no title issues raised. And we believe, again, that the title issues that are being raised here are just pretextual.
All right. And Thank you. And then how many witnesses do you expect to call today in your case in chief?
Mr. Ghazi, Mr. Reynolds, that's it.
All right. Thank you, sir.
Thank you, Your Honor.
All right, Mr. Deloach, any opening remarks you want to add?
Yes, Your Honor, I appreciate it. And Your Honor, I'm going to refer to the contract, which was attached to the pretrial order. Do you have it? I've got another copy for the court if you.
I've got the one attached to the complaint,
Okay,
if you think
that's-
those are going to work.
You know what, Your Honor, may I approach and just hand you the one that's attached to it? This is plaintiff's exhibit 1. This is what they indicate. And it's got both that and the amendment. So I'll refer to it, and I thought it may be helpful for the court. Your Honor, obviously, I'm not going to repeat what you've just heard from. Yeah, I know it's challenging.
But let me pause you there. I don't know if this is going to be a good one for the record. Do we have maybe a better printed copy? I mean, honestly, the one on the complaint reads better.
Okay, well then, that's the best copy I have, Your Honor. If you have the one that was attached to the complaint and it reads better, then please refer to that one.
Okay.
That is, in fact, the best copy I have. So
All right.
I have a hard time at times as well. And if the one attached to the complaint doesn't have the amendment, then it does. Okay, all right. Well, then please refer to that one, Your Honor. Your Honor, this matter does arise from that real estate agreement you have in your hand. Mr. Reynolds, Gene Reynolds Realty is both the buyer's broker and the seller's broker on the contract. The original closing date was October 15th, 2021. There are some important terms of the contract that the courts will be asked to take a look at, I believe, in making a decision in this case. We start with there are numbered pages down at the bottom. This is 2 of 8 of the original contract. Paragraph B1, there is a provision for examination, and it says the buyer may examine title and obtain a survey of the property and furnish seller with a written statement of title objections at or prior to the closing. If seller fails or is unable to satisfy valid title objections at or prior to the closing, or any unilateral extension thereof, which would prevent the seller from conveying good marketable title, then buyer, among other remedies, may terminate the agreement without penalty upon written notice to the seller. And so that's one important term that I'm gonna come back to. Is the facts will be developed, we anticipate in this case. There is and I'm going to go in order of the pages in the contract because I think that's easier, Your Honor. If we flip to the next page, there's provision regarding earnest money. We do have a counterclaim in this case. You'll see it's subparagraph 7 under earnest money. And in short, Your Honor, here the broker, the plaintiff in this case, is holding earnest money of $10,000.
I'm sorry. Let me pause you again there. I just want to make sure I've got my eye on these provisions.
Sure.
This
is page 3 of 8 at the bottom of the contract.
Well, look, and the exhibit 1 on the complaint is page 1 of 10. So maybe I better use the one that you have originally. In fact, I think what I was looking at was titled the seller brokerage engagement agreement, maybe not the purchase and sale. Give me one moment.
Sure, Your Honor.
Okay, here we go. All right, so I found the title provision, and now we're looking at the earnest money part.
Yes, Your Honor.
All right, I'm on track.
Okay. And again, I'm going to hit the high points here. What the court will find is that this earnest money provision has that the plaintiff is holding the earnest money. And if there's an earnest money dispute, if you look at there's provision regarding disperse the earnest money, the evidence will be the plaintiff. We've been 3 years since this happened, and the plaintiff has done nothing with the earnest money. Is still holding the earnest money. There's been no disbursement, no letter indicating how they'd like to disperse it. They're just still holding the earnest money. So, Your Honor, our counterclaim really, I've looked at the law further, and I really believe our request in this case, Your Honor, is that the court order that the plaintiff interplead the funds. The seller's not here to represent themselves. We're not going to ask this court to make a decision about who's entitled to the earnest money without the seller having an opportunity to be heard. But we do think that it's a breach of contract for the plaintiff to continue holding the earnest money without interpleading it into the court. So our counterclaim is to interplead the earnest money, Your Honor, so that can be decided between Mr. Ghazi and the seller. That's all you'll hear about that probably, other than a little bit of evidence on it until we get to closing. If we then turn to page 5 of 8 of the contract, C1, section C1, notices. And this is a very important provision, Your Honor. This says all notices hereunder shall be in writing, legible, and signed by the party giving notice. In the event of a dispute, the burden shall be on the party giving notice to prove delivery. The requirements of the notice paragraph shall apply even prior to this agreement becoming binding. And then this is important. Notices shall be delivered in person, by courier, overnight delivery, or by certified registered U.S. mail, hereinafter delivery service, or by email or facsimile. The person delivering or sending the written notice signed by a party may be someone other than that party. And Your Honor, we believe the evidence is going to show that their claim that Mr. Gazi terminated this contract will not be borne out by the evidence. There was one text message where you heard Mr. Johnson read from that text message where Mr. Gazi says, "Gene, I'm sorry, we're going to have to walk away and forfeit the EM. Sarah is pissed at me." But the evidence will show subsequent to that, there's a good bit of communication from Mr. Gazi to his broker, the plaintiff, and from the broker, the plaintiff, to Mr. Gazi, during which you will hear evidence that there's even communication where the broker tells him that there would be subsequent steps to be taken to terminate the contract. And we believe, Your Honor, that's because the contract is very clear that it must be signed by the party. And that didn't happen here. There was no termination of this contract by Mr. Gazi until the until the seller failed and never responded to multiple efforts to communicate about the title objections that were submitted. So again, we believe that provision will become very important after the court hears the evidence. Similarly, there's a default provision below that, which indicates that in the event this agreement, I'm reading from 2B, in the event this agreement fails to close due to the default of the seller, buyer may either seek specific performance of the agreement or terminate the agreement upon notice to the seller and the holder, in which case the earnest money deposit and all other payments that has been paid towards the purchase of the property shall be returned to the buyer following the procedures set forth elsewhere herein. We believe the evidence will show that ultimately, through counsel, Mr. Gazi terminated the agreement only because he could get absolutely no response from the sellers. It will be undisputed that the sellers never responded to multiple efforts to communicate with them about what they believed were valid title objections. And that is also 2D is where you see the provision for attorney's fees that Mr. Johnson referred to right below. And it does say that the prevailing party is entitled to their reasonable attorney's fees and expenses. Like Mr. Johnson, at an appropriate time, I'll be stating in my place those fees on behalf of Mr. Gazi. So those are the important terms of that initial contract. Now, you will hear, the evidence will show that Mr. Gazi and his wife went to Italy for a honeymoon. And he will tell you, quite frankly, it all went fast and he was not thinking about the closing date on October 15th. I mean, basically, he'll tell you he forgot it was coming up in the midst of the whirlwind of getting married and his honeymoon. And so there is communication where they request an extension in order to close. And in that evidence will come in. And importantly, the parties agreed to an extension. And that is the amendment dated 10/14/2021. That is also attached to Exhibit P1, Your Honor. And it's much more legible. I don't know if the court wants to look at the copy that I either handed you or if it's attached to the complaint. But again, Your Honor, this is very important. This was accepted and signed by all the parties in a timely fashion. Mr. Reynolds signed it on behalf of the buyer and the seller. And it indicates that the closing shall be extended till Friday, November 12th, 2021. That is not conditional. It does not say conditioned upon such and such happening. It just says the closing shall be extended to Friday, November 12th, 2021. Paragraph 2 says the buyer shall deposit an additional $10,000 in escrow within 5 business days of the fully executed extension. So 5 days after the execution of this, Mr. Ghazi is supposed to tender $10,000 additional earnest money. It does not say only upon that occurring will this amendment become valid. In fact, Your Honor, while you will hear testimony about Mr. Ghazi on a Sunday writing a check and putting in mail when he returned from Europe so that it would be done in a timely fashion, you will hear testimony about that. The court actually doesn't have to decide whether he actually sent the earnest money, in our opinion. We believe whether or not he sent it, while he will testify that he did, and we will, whether he did or he didn't, is not definitive because there is a valid and binding agreement. And Your Honor, in closing, certainly I'll be citing the law, which talks about the fact mutual promises are sufficient consideration. And so without getting too far into the law on that, I'm highlighting why that evidence is important because you in fact don't have to make a decision on that. This was a valid and binding amendment that extended the closing till November 12th. And if the earnest money wasn't paid, then Mr. Gazi owed it, and they should have told him that they didn't receive it. And importantly, Your Honor, you will see that all of the communication from Gene Reynolds in writing, not once does he tell Mr. Gazi, by the way, we didn't get your earnest money. Can you send it? Not once will you see that in the written communication from the plaintiff. Instead, everybody moved forward knowing there was a valid extension. It was only after the issue that has us here today occurred that suddenly the plaintiff decides, oh, wait, that extension wasn't valid. So we get to, Your Honor, important evidence that we believe Mr. Reynolds, during his testimony, that he will have to admit to the court upon my examination. He'll admit that his office drafted the amendment and signed it electronically. While he claims that he didn't receive the $10,000 earnest money, and my client admits it never cleared his bank account, Mr. Reynolds will have to admit he never sent a written request to Mr. Gazi for it to be paid, not even in text or email. He will admit that Mr. Gazi never sent a letter or other signed document formally terminating the contract. And that's important under the terms of the contract. In fact, the court will see that Mr. Reynolds wrote Mr. Gazi on October 21st, 2021 about the potential termination. And in that, in conclusion, Mr. Reynolds' letter, the plaintiff's letter, states to Mr. Gazi, if you wish to move forward with the termination, we will draw up an escrow disbursement stating that the seller will retain the $20,000 deposit. That's on October 21st. No reference to not receiving it, the escrow, in no indication that he thought the contract was already terminated. Mr. Gazi did not respond and indicate that he still wanted to terminate the contract. In fact, the evidence will be that he didn't. He instead, having looked at the title report, his testimony will be, having looked at the title report, he hired other counsel because he had concerns because the title report indicated that this property could not be subdivided into tracts smaller than 5 acres. It's a large tract of land. He learns upon getting the title report that it can't be subdivided into tracts smaller than 5 acres. That's a problem for Mr. Gazi. In his hope, he'll tell you in his testimony, his hope after paying cash was to refinance this, a cash out refinance, which is what he does on all of the properties he buys. And in talking to his his testimony will be in communicating about the potential for refinancing. That was a problem. He hired other counsel. That other counsel then, Mr. Reynolds will admit he received an email from Mr. Gazi's counsel indicating, her name was Ms. Shortridge, indicating that there were objections to the title. Please respond and let us know how you're going to address these. Now, that was not a termination. That was actually an effort to get the transaction closed. No one on behalf of the seller, and this is undisputed, no one on behalf of the seller responded to the letter from Ms. Shortridge objecting to certain issues of title. Mr. Gazi even followed up with the plaintiff by text saying we hadn't heard back. Are y'all going to respond to the title objections? No response. Instead, Mr. Reynolds' attorney sends a demand to Mr. Gazi to pay his real estate commission. Now, notably, when the court sees this demand, the demand was from the plaintiff's attorneys, and it was sent to Mr. Gazi, even though he had not terminated the agreement yet. He hadn't terminated the agreement, yet they're demanding the real estate commission. And that demand did not demand that Mr. Gazi close on the transaction, which we believe they could have demanded based on the title objections. They could have said, we don't believe these are valid. You got to close. That's not what it did. It did not demand that he close on the sale, and it did not demand that he pay the $10,000 earnest money. It demanded that it pay his real estate commission. That was all.
And wasn't that like 2 months after the amended closing day? Was it in December?
No, Your Honor, that's October 26th. October 26th. That's before Mr. Gazi's attorney ultimately had to terminate for failure to receive any response from the sellers. So ultimately, Mr. Reynolds, the testimony will be Mr. Reynolds did not seek to have Mr. Gazi actually close on the transaction by November 12th. Instead, the focus was on his recovery of a commission. And the evidence will show that despite communication from the plaintiff and his counsel, never once do they mention the title objections. Never once, after receiving them, never once do their communications back to Mr. Gazi mention the title objections. On November 11th, Your Honor, Ms. Shortridge, Mr. Gazi's attorney, follows up a second time about the title objection, saying, I sent one letter, haven't heard. Are you all going to respond to the title objections? Mr. Reynolds will have to admit that letter was ignored. Neither Mr. Reynolds nor the seller ever responded to any communication from Mr. Gazi or his counsel inquiring about the title objections and a possible closing. As a result, the closing date, November 12th, came and passed, them having heard nothing back and making an effort to try to resolve it and see if they could close. So on November 15th, Ms. Shortridge sent a termination letter saying, you were completely non-responsive. We have no choice under the contract but to terminate. And so that is what we believe ultimately we will argue, was a valid and appropriate response to the failure of the seller to respond in any way for an extended period of time. Now, you'll hear that Mr. Johnson's already indicated that 2 months later, the plaintiff was able to sell the property at the same price, earn the same commission. We know that's not an offset. That's not our argument at all. Our position, Your Honor, is that the plaintiff, every communication is focused on getting his commission from Mr. Gazi. He has an opportunity to get double commission. He wasn't trying to close this deal. He was trying to get commission and turn around and be able to close it again, is what we believe the evidence shows. Now, ultimately, Your Honor, Mr. Gazi will testify he was not given the opportunity to make a choice about whether to close on this property. Had there been a response to the title objections, if they'd cured them, he certainly would have closed. If they told him they were uncurable, his testimony will be, he may have still closed. And so that, we believe, is what resulted in the termination of this contract. That being the seller's failure and refusal to respond in any way to these title objections. He didn't have a chance to make a choice about whether to close or not. And so, in conclusion, Your Honor, we believe the evidence is going to show there was a valid extension a failure on the seller's part to respond to his effort to actually close, and then an ultimate termination based on the seller's failure to respond. And for that reason, Your Honor, we believe Mr. Ghazi is entitled to judgment in his favor and will be asking for our attorney's fees under the terms of the contract.
All right. One follow-up for you, Mr. Deloach.
Yes.
Based on your review of the initial contract and the amendment, I'm curious, is there any kind of a clause that we would generally refer to as like a time of the essence clause?
There is, Your Honor.
Where would that be?
There is, it is on page, I believe it's 6 of 8 of the original contract. And it is just above section 5. It's subsection 4N.
All right. I see.
Time is of the essence.
All right. And then the same question I had for plaintiff was how many witnesses would you anticipate calling, assuming your client is called in the plaintiff's case in chief?
Your Honor, Mr. Gazi is our only witness. So
All right.
we can, obviously, it's in the court's discretion, I believe, to allow me to handle my direct at whatever point in time the court chooses, whether it's when Mr. Gazi's called in the case in chief or whether it's in our case. So we have no preference, sure.
Okay. Thank you, sir.
Thank you.
All right, then. Let me turn it back over. Mr. Johnson, sir, you can call your first witness.
Yes, Your Honor. Well, as Mr. Deloach anticipated, I will call Mr. Ghazi. I'm calling obviously as an adverse party for purposes of cross-examination.
All right, Mr. Guys, if you could step right on up here, sir, the deputy's going to swear you in.
Go there.
That's right. If you can just stand right there and pull the chair back.
Raise your right hand. You swear no conflict with testimony about the court today is the whole truth and nothing but the truth?
Sir.
All right, then. Put directly into your microphone at all times. And if you can state your first and last name and spell it for the record.
Okay. My name is Babak Robert Ghazi, and I go by Bobby.
Spell it.
Oh, Babak, and the last name is Ghazi. Thank you.
Good morning, Mr. Ghazi.
Good morning.
I want to ask you a few questions here today, obviously, Mr. Ghazi, and as you know, I've asked you questions previously when we had your deposition at Mr. Deloach's office. So this should all be familiar territory.
Sure.
Just to start off, Mr. Ghazi, you heard me obviously in my opening statement say a few things about you. You've got a degree from Georgia Tech in engineering, correct?
Yes, sir.
Is it computer engineering?
Yes, sir.
You've worked in sales, engineering, product development?
Mhm.
Need to make sure you say yes or no for the court.
Yes, sir.
Okay. You have multiple corporate entities that you have set up over the years.
Yes, sir.
And in addition to your engineering work, you invest in real estate.
Yes, sir.
Okay. And in fact, you're always looking for real estate investment properties.
Yes, that's correct.
You have a portfolio of several real estate rental properties,
Yes, sir.
and both commercial and residential.
Yes, sir.
You've set up different corporate entities to operate those properties.
Yes, sir.
And so this property, this 6550 Gay Road property, this is, as we say sometimes, not your first rodeo,
Sure.
right?
Yes, sir.
Okay.
Not the
All right.
first.
All right. The court has already seen, Plaintiff's Exhibit 1. I'm going to go ahead and okay. We've got multiple copies.
So just,
Okay. Your Honor, may I approach?
Yes, you may. And I think no need to ask for permission throughout this direct.
Mr. Gazi, I'm going to show you what we've marked as Plaintiff's Exhibit 1 and ask if you can identify that.
Yeah. It says P1 on it.
Okay. That is in fact the purchase and sale agreement where you agreed to buy the property at 6550 Gay Road, correct?
Yes, sir.
Okay. And Your Honor, we removed two evidence.
Any objection to P1?
no objection, Your Honor.
P1 is admitted.
Thank you, Your Honor. Mr. Gazi, I want to go over a few key points with this momentarily. Now, this is for some property in Meriwether County, correct?
Yes, sir.
And I believe at the time you had a friend who lived or had property there, wanted to be maybe close to them.
Yeah, he referred me to Gene.
Okay. So that's how you got to know Gene Reynolds?
Correct. That's correct.
Okay. And you researched some properties, I believe, for sale even before you contacted Gene.
Yeah, I think I sent him about a dozen properties that I was interested in.
Okay.
Oh.
Mhm. Oh, okay, yeah, that can get. We can just remove those pages. Okay. So you see this one. Yeah. Okay. Your Honor, I understand. I've been speaking with Mr. Deloach, Plaintiff's Exhibit 7. He has no objection.
No objection, Your Honor.
All right. And what is P7? Just identify it for the record.
Mr. Ghazi, I'm going to show you what we just marked as Plaintiff's Exhibit 7. Can you identify what that is?
That's text messages about various properties that I'd sent to Gene that I was interested in making offers on.
Okay, and you just testified that you sent him information about multiple properties other than the Gay Road, correct?
That's correct.
And this is what you're talking about?
Correct.
Okay. And
And just
you-
for the purposes of the record, Mr. Johnson, P7 is admitted.
Thank you, Your Honor. So you were asking him to make multiple offers on multiple properties?
I was throwing out numbers of what I was interested in. I'd like to put one offer in at a time, try to get a good deal on it, and move on to the next one. That was the intention.
Okay. Did you say in here you wanted to make one of these offers at a time?
No, we spoke on the phone about that, and he berated me and cussed me out and said he would only deal with one property at a time. So that's not in the text for that reason.
In fact, you sent him just one after the other one evening. That's what all these are.
Well, I sent him these, and then I called him to speak with him about my text to explain them.
Okay. Do you understand that if he had taken you literally at your word to make offers on all these properties, you could have had binding contracts on all of those properties?
I don't know. I'm not sure exactly how that would be construed, but so I don't know.
Well, you're a sophisticated real estate investor, correct?
You're calling me that? Yeah. I've done real estate deals. Yes.
Okay. And you understand that if you submit an offer that a seller accepts, that's a binding contract. You understand that, don't you?
Sir, these aren't offers. These are just numbers on properties.
But you understand that if an offer is submitted and accepted, you have a binding contract?
Correct.
Okay. And you told him, let's offer 81.9 on this, for example. Let's offer 77 on this, correct? Those were your words.
That's correct.
So again, if he had taken you literally and, okay, Mr. Ghazi's telling me to make an offer, if he'd written up an offer and sent it in, you would have been bound by it if the seller had agreed, correct?
Yes, I could see how you can see that, but I'm not
Okay.
going to sign multiple offers.
Now, going back to Plaintiff's Exhibit 1 in the subject property, 6550 Gay Road in
Yes, sir.
Meriwether County. You went and visited that property before you put an offer in,
That's correct.
and you took, at that time, Sarah was your fiance, now y'all are married, correct?
Yes, sir.
So I'm going to call her your wife. Is that okay?
Sure.
Okay, all right. So you took your wife down to see the property?
Mhm.
Yes?
Yes.
Okay. She went back at least once with a girlfriend of hers, I believe Lauren, to look at it?
Yeah, she went and showed it to one of her friends.
Okay. And she went back and showed it to her father?
She did. I don't know how many visits it was, honestly. I went there once. She asked to go back after we went our initial, but I'm not sure how many times it was.
Okay, but it was several times.
I'm not sure.
Okay. And Gene was accommodating, let him come in and see the property whenever, correct?
He let him see the property. Yeah.
Okay. I believe he had an assistant, Julie, at the time, who Sarah became rather fond of.
Yes.
Okay. So you and she then ultimately talked about making an offer on this property.
Yes, sir.
go back on the subject property.
Yeah, no problem. Yes.
Connor, enter into evidence plaintiff's exhibit to Gazi, can I ask you to identify, take a look at that, what that is
Okay. It's just some text messages.
between you and Gene Reynolds?
I'd like to review it if you don't mind.
Sure.
Sure. Yeah, these are texts between me and him. Me and Gene
Your Honor,
Reynolds.
I'm going to move to admit plaintiff's exhibit 2 into evidence.
Any objection?
None, Your Honor.
Admitted.
Mr. Ghazi, these texts refer back to the time period between around September 2nd and September, looks like 4th of 2021. Is that correct?
Looks like it goes a little past that. Yeah. I see a September 5th. Yeah, it looks like 2nd through the 5th.
Okay, all right. And these are texts between you and Gene Reynolds about the Gay Road property, correct?
That is correct.
All right. So I'm taking those results.
Oh, yeah, perfect.
Your Honor, I'd like to send these to you to read along.
Thank you.
P1, P2, and P7, but then without objection. Looking at plaintiff's exhibit 2, Mr. Ghazi, let's go through those texts. Can you confirm that these are in fact texts between you and Gene Reynolds?
Yes, sir.
And in fact, if you look at the second page, down towards the bottom, it says, "It's Bobby Gazi. This is my fiance's phone number. I'm texting her because my phone broke," correct?
Yes.
Okay. And that page, are you making an offer on the property for $485,000?
On that page. Yeah, after I spoke with him on the phone, he gave me a price that he thought they would take, and I was responding back on that.
Right. And you initially said, "We'll take it at 585," and then said, "Oops, 485," correct?
Yes, sir. It's a typo.
Right. And on the third page of that group, the Reynolds texted you back and said that they, being the sellers, signed on the 50 acres and cabin at 6550 Gay Road, correct?
Yes, that's what it says.
And then you texted him back asking about bringing Sarah's dad to the property. We talked about that.
Yes.
Next page, page 4 there is again just more about the signing and closing on the property at 6550 Road, correct?
Give me a moment. I'm trying to get to your. Yeah, we're talking about the signatures.
Right.
Yes, I see that.
And then the last page looks like screenshots or maybe pictures of signature pages for that contract, correct?
Yes, that's what it appears to be.
All right. Now, Mr. Gazi, if you could look at plaintiff's exhibit 1, which you should still have in front of you there, the purchase and sale agreement.
Yes, sir.
The offer date up there was September 3rd, 9/3/21, correct? On the top of the first page?
Yes, sir.
Right. And if you go to the numbered pages down towards the bottom, it's page 8 of 8. Can you flip over to that?
Okay,
Are you there?
I am.
Okay. And you've electronically signed the contract there, correct?
Page 8 of 8 doesn't have any signatures. Is this what you're talking about? It says
Page
8.
eight.
It says 8 of 303 at the bottom. Just P1?
Yes.
8?
Sorry, do you mind? I don't mean to.
No, you're fine.
Okay.
Let me just try to turn until I see
Yeah.
a visual similarity. This page?
Yes, yes.
Okay, it's 13 is what it says here.
Okay,
13?
13 of 303. I
Yeah,
was looking at the 8 of 8 there.
Oh, okay.
Okay, sorry for the confusion.
All good. Yeah, I'm here.
Okay.
The signature pages.
Yes, sir. And do you see that down at the bottom, it has a binding agreement date of 9/5/2021?
Yes, sir.
Okay, so you understood that at that point you had a binding contract to purchase this property?
Yes, sir.
All right. Going back to page 1, there's a provision.
One, sorry.
I'm sorry.
Which one are you
Page
talking?
1 of P1.
Oh, okay. The front page.
Yes,
Okay.
sir.
Got it.
Go down about halfway through paragraph 6. It says closing attorney law firm.
Yes, sir.
That's left blank at that time, correct?
Appears so. Yes, sir.
Okay, but you ultimately chose the attorney you wanted to close this property for you.
Yes, sir.
And that was Brandon Reisman at Southeast Closings.
I chose Southeast Closings. They have various people that I've dealt with.
Okay, but you've worked with Southeast Closing Firm on other properties.
Up until that point, yes. I've
Okay.
fired them since.
Okay, all right. But you hired them, they were your lawyers.
Correct.
Okay. Go down to paragraph 7B, it mentions earnest money.
Yes, sir.
Says $10,000, correct?
Yes, sir.
Now, again, being involved in real estate, you know that earnest money is a very important part of any real estate deal, don't you?
Yes, sir.
Okay. And you wanted to make sure that that earnest money was received,
You always want to make sure it's received.
okay? Because you and Sarah really wanted this property.
Look, we were looking at it as a rental. We were going to use it. We weren't married to the property, if that's what you're trying to say.
But you wanted to buy it.
Yes, wanted to buy it. Correct.
Okay. And you wired the funds to Mr. Reynolds, to Gene Reynolds' property.
Correct.
So you had his wiring information,
Yes.
and this was going to be a cash sale, correct?
It was a cash sale on the contract, but I was exploring financing options. Like my attorney said, I always, if I buy something with cash, I cash out refi it. I've done it 100% of the time on 7+ properties. So that was my intention with a cash close.
Does that say that anywhere in this contract?
I'm sorry, I don't normally put that in contracts.
Okay. So as far as you know, it's not in this contract.
No, it's not.
So Mr. Reynolds wouldn't have had any reason to know what you plan to do in the future.
No, we were talking about it. He talked about making an Airbnb and building a tree house on the creek and several things. He knew our intention for it was to rent it and to
Right.
use it for our own. But I mean, I don't know. I don't know if that's normally put in a contract.
No, I'm talking about that you were going to go back out and get a loan later down the road.
I discussed it with him. Yes, he knew about that. There was some communications about that.
But the contract itself says it's a cash sale.
Correct.
Okay. Now, as of that date, as of September 5th, the binding date, you had 40 days until closing on October 15th.
Sorry, from this initial contract you're referring to?
Yes.
40 days from,
From the binding date.
yeah, that sounds about right.
Okay. 30 days has September, and then you got 15
Sure.
more in October, so that
Sure.
makes it 40 days.
Yeah, according on the initial contract.
Okay.
Prior to the amendment, yes.
Right, all right. Gazi, I'm gonna show you what we marked as Plaintiff's Exhibit 3. And ask you if you can identify that.
Okay.
Those are in fact some text between you and Gene Reynolds confirming his wiring and routing number, correct?
That is correct.
And in fact, the contract said the wire was supposed to be made within 2 days of the binding date, didn't it? See in the earnest money, paragraph 6 on that first page.
2 days. Okay.
So you didn't wire the money to him until,
Well, it was over a weekend.
you wired it on September the 8th, is that right?
I'm not sure. I don't remember exactly the date I wired it.
Your Honor, we're moving to introduce Plaintiff's Exhibit 3. I don't believe what it had.
No objection, Your Honor.
Minus 3 is admitted.
Thank you, Your Honor. Yeah.
Thank you.
So let's look at page 4 of that exhibit.
P3, you mean?
Yes.
Okay.
Yes, sir. P3, page 4,
Okay.
fourth page there. That was you asking about needing ABA routing to wire the earnest money to Gene, is that correct?
That's right.
And he sent that information to you?
He did.
Okay. And then on the next page, down towards the bottom, it says Thursday, September 9th, EM of $10,000 was wired today, correct?
Yep.
And then you followed up with him again on the 13th to say, did you get the earnest money?
Yes.
So you really followed up with him to see if he got the first earnest money, correct?
I did. Yes.
Okay. Now, you talked earlier about the closing firm that you used. You also know that in connection with hiring a firm to do the closing, they run a title search, don't they?
Yes, sir.
And you expected that the Southeast Closings would do that for you, correct?
Yes, sir.
And in fact, they did, correct?
I didn't ask for the title search until much later when they gave it to me. So they did, but I was not made aware of it just yet until I asked for it.
But you would have expected they would have done it fairly early on in the process.
I would expect they would have done it. I don't know about the timing necessarily.
Mr. Gazi, I want to show you what we want as Plaintiff's Exhibit. When we identified that as a series of texts between Sarah on your behalf and Gene Reynolds.
Yes.
Okay. Your Honor, I'm going to move to admit Plaintiff's Exhibit 5.
No objection, Your Honor.
5 is admitted. Thank you.
Now, Mr. Gazi, let's go through Plaintiff's Exhibit 5. This is in fact an email or text, I'm sorry, from your wife, Sarah, to Gene Reynolds dated Tuesday, October 12th, correct?
Correct.
Now, you were in Italy at the time,
Yes, sir.
and you were there, I think Mr. Deloach said for you're either getting married or for a honeymoon, correct?
I was getting married and then it was a honeymoon. Yes, we were eloping.
All right. Now, I can understand that that might be much more exciting than thinking about a real estate deal, but you did know that you had a closing set back in the States, back in Atlanta for October 15th.
Honestly, I was caught up in getting married and the excitement, and all that. And it just totally slipped my mind.
But you had known that since September 3rd when you put the offer in.
I mean, I just told you, I just totally forgot. I was like getting married, getting photographers, dresses, all this stuff set up while we were over there, and it wasn't top of mind at the time.
When did you leave to go to Italy?
I'm not exactly sure, but we were there for a couple of weeks.
Prior to or after the 12th?
I'm not sure.
Did you, prior to going to Italy, before you left, did you reach out to Gene to let him know that you were going to be out of town in the 2 or 3 days leading up to the closing?
I don't remember.
Did you ever contact him to see about maybe doing a mail away closing if you were going to be out of town?
It's very difficult to do a mail away. Getting notarizing in Italy, the laws are completely different, so it's not something very easy to be done.
But you
So
know,
I did not look into that.
but you know it can be done.
I don't know it can be done. I've never done it, but I've looked into it.
When did you look into it?
I'm dealing with a closing right now where I had to look into it. And there's apostle certificates and court certifications and all that. And it's not very easy to do.
So at this point, though, we're not talking so much about how difficult it might be to do the closing as
Sure.
it is that you needed money, correct?
I needed more time to get all the money into one account. That's correct.
Okay. Well, you knew as of September 3rd that you were going to pay $485,000 for this property, correct?
I'm sorry, can you repeat that?
You knew as of September 3rd that you were going to be paying $485,000 for this property.
Yes, sir.
And you knew as of September 3rd that it was supposed to be a cash closing.
Yes, sir.
So you knew as of September 3rd that by October 15th, you needed to have $485,000 cash to close.
Yes, sir. And I needed more time, and that's why I asked for an extension that I received.
So you're the one who wanted more time, correct?
Yes, sir.
The sellers did not ask for more time.
I don't know what the sellers did.
You're not aware that they ever asked for more time to close, did you?
I don't want to speculate. I don't know what the sellers did.
I'm saying to your knowledge. not
To
asking
my
you
knowledge,
to your
I don't know.
knowledge, sellers were not the ones asking for more time here.
no,
Okay.
to my knowledge.
And to your knowledge, it wasn't Mr. Reynolds who was asking for more time.
No, sir.
Solely you, Babak Ghazi, asking for more time, correct?
Yes, sir.
To get together money, correct?
More time to get together the money in one account. Yes.
That you knew since September, that you had known since September 3rd, you should have had together.
Sure.
And in fact, it was at that point on page 2, if you look at this, what did Mr. Ghazi, what did Mr. Reynolds tell you?
I'm sorry. Which one? My desk is a little
Plaintiff
full.
Exhibit 5
Okay.
and the second page. See Gene's response back to Sarah and you?
Yeah. The congratulations.
Yes. And
Yes,
what's
sir.
the one below that? What does that say?
He's asking if I have someone to sign for me.
Okay.
A POA, apparently.
And he also said he thought the seller in Arizona had already signed. Correct?
Yes, sir.
Okay. So then the bottom of the page, and it carries over, let's just go to page 3 because it's the whole text is there. What did Gene say to you?
Page 3,
Yes,
where it says Bobby says he needs more time. That part.
the top of the page, sir.
Another idea. How about have the closing attorney email closing package to the hotel in Italy and you sign and FedEx back to closing attorney? Okay.
So Mr. Reynolds did suggest that that was a possibility.
Yeah, he suggested that was a possibility.
Okay. The ones I'm gonna show you now, what we've marked as Plaintiff's Exhibit 8. I'm sorry, Mr. Gazi.
Yeah,
Gazi.
it's okay.
Plaintiff's Exhibit 8, and ask me if you can identify that.
This is an email from my closing attorney.
Okay. Your Honor, we would move to admit into evidence Plaintiff's Exhibit 8.
We're not going to object, Your Honor.
All right, PA is admitted.
So, Mr. Ghazi, in follow-up to Mr. Reynolds' suggestion of having the closing attorney send you the documents in Italy, your own closing attorney, do you have another copy? Yeah, I'm sorry.
No, it's okay.
Yeah, I've got it.
Sorry.
Your closing attorney or the firm actually did email you documents to sign in Italy, didn't they?
This email was sent to me, but I had never seen it until after I had to get discovery documents. And reading from this, it's asking about a U.S. notary while we were in Italy. So this is not, there aren't U.S. notaries in Italy.
Okay, well, let me ask you this, though. Just the email to confirm is from your closing attorney that you
It
chose,
is,
correct?
correct.
And it's to you.
It is,
That is in fact your email, bobby@ghaziproperties.com,
correct.
and it's dated October 13th, 2021.
Mm-hmm.
Yes?
Yes,
Okay. So the day before that, Gene had suggested to you that the documents could be emailed to sign, correct?
from his text, yes.
Yes, okay. And you knew that you had a closing that was supposed to occur here in Atlanta on October 15th, correct?
Yes,
And you say you didn't see this document until you got into discovery in this case?
yes, sir. I was traveling. This is while I was getting married. This is right in the middle of it. So
Yeah, but this closing was a pretty important thing to you, wasn't it?
it was important, and that's why I asked for more time. It's a reasonable thing to ask in real estate deals. Pretty common, in fact.
Now, turning back to P5, Mr. Ghazi.
One moment. Yes, sir.
Go to the third page down at the bottom. Is that a text from Sarah to Gene Reynolds?
Yes, sir.
And that's reflecting that you've offered to put up hard earnest money, correct?
Yeah, I offered to put up more money.
More hard earnest money, correct?
Yes.
Yes, okay. And that was to be $10,000, correct?
Yes.
Now, Mr. Ghazi, if you'll look back at Plaintiff's Exhibit 1 and go to the last two pages, which is the amendment.
Yes.
And that is the amendment agreement that we've heard quite a bit about this morning already.
Yes, sir.
Okay. You signed that electronically,
Yes, sir.
and this was on October 14th, 2021.
Yes, sir.
Were you still in Italy when you signed that electronically?
Yes, sir.
So you received this via email?
Electronically. Yeah, I mean, DocuSign or whatever this is. Yeah.
By email?
Yes, sir. I believe so. It might have been a text. I don't remember how he sent it exactly. It was 3 years ago.
And yet you say that you didn't receive or don't remember receiving Plaintiff's Exhibit 8, which was an email from your attorney just the day before.
Yeah, correct.
So you received some emails while you were in Italy and not others?
Well, I was specifically looking for this email when he said the extension was sent so that I could sign it on time. So I searched for Gene, I found it, I signed it, and that's where we're at on that.
And the fact that Gene had alerted you to the fact that your attorney might be able to email you documents to sign for the closing didn't alert you to look for that email prior to discovery?
No, sir.
Now, Mr. Ghazi, you've already told us here that you wired the initial $10,000
Yes, sir.
earnest money, correct? Because you realize how important that was to the contract.
I didn't say that's why I wired it, but I wired it the first time
Well, you
because
know
it was easy.
You know it's important.
Sure.
Okay. And in fact, as the court noted, there is a provision in the contract, in the purchase and sale agreement, that if you look down, it's 11-303,
Where am I looking at? I'm sorry.
Plaintiff's Exhibit 1.
What page?
If you're looking at the 11/303 down at the bottom, it's page.
11-303. Okay, hold on one second. Give me a second, please. Okay.
There's a provision there, paragraph N, about 3/4 of the way down, that says time is of the essence, correct?
Sure.
So you knew that it was important to get the first $10,000 to him in a timely fashion.
First time I've ever heard of this provision is today, so that's my answer to that. I've never seen that before. I've never read to that point before.
So are you saying that you never read your purchase and sale agreement?
I read the contract, but I don't remember reading that part.
You make it a habit of signing contracts you haven't read?
I read the contract. I don't remember reading that part. But I
And
see
you
what
would
it
like-
says. But I see what it says. Time is of the essence. Yes.
Okay. And you would likewise have understood that it was important to get the earnest money in to Mr. Reynolds for the amendment, correct?
Yes, sir.
In fact, it says it's to be sent within 5 business days.
Yes, sir.
Now, I believe that your attorney is going to present into evidence this morning a stub from a checkbook
Mm-hmm.
that shows a $10,000 check was written out of your checkbook, right?
Yeah. For months throughout this trial, we were discussing that, and I'd given it to him. I don't know exactly how long back, maybe a month or two ago, and I think he just sent it to you yesterday.
Okay.
But yes,
So when we filed the complaint, you filed an answer, remember that?
with my attorney, yes, we filed an answer.
Right. You remember that your answer has a lot of exhibits attached to it?
Yes, sir.
Okay. The fact that you had written an earnest money check and had a receipt for that, or a paste or check stub for that, didn't occur to you to put that in with the package when you filed your counterclaim?
When Jeff and I were discussing it, I was looking for it. I had not yet found it, and preparing through this trial, I'd gone through my documents and I had located it. And this was probably, I want to say, month and a half, 2 months ago. I'm not sure exactly when I'd give it to Jeff, but
Okay.
he's had it in his possession for some time now.
Okay. And you remember you were served with written discovery request in this case, where you had to answer questions and produce documents throughout the course of the case? You
Yes,
remember
sir.
that, right?
Yes, sir.
And me, on behalf of my client, asked you to produce all documents that would have been relevant to the case, essentially, correct?
Yes, sir.
And you didn't produce the check stub at that time?
I had not found the check stub at that time, sir.
Okay. And I took your deposition in this case?
Yes, sir.
And your deposition was September 8th, 2023?
I'm not sure of the date, but whenever it was. Yeah, that'd be helpful.
That jog your memory.
Okay. September 8th. Yes, sir.
So, over a year ago,
Okay.
right? Brett?
Yes.
Okay. You didn't provide me with that check stub a year ago, September 8th, did you?
No, but I told you I'd mailed the check in that deposition.
And I asked you if you had any documents and you didn't, did you?
I said I have not located any documents.
This document just miraculously turns up the day before trial.
I don't know how you want me to answer that.
Okay.
I found it when I was preparing for trial.
Your Honor, not to interrupt, I'll just, I just don't want, I'll own the fact that he sent it to me. And frankly, I overlooked, I'm just gonna, I have to take that. I overlooked it. He sent it in preparation for the last trial. Whether the court allows it or not will be up to the court, and we'll live with whatever that is. But I just wanted to state that in fact, he did give it to me, and I just overlooked providing it to Mr. Burke, and I'll deal with the consequence of that. So I just wanted to state that.
Well,
Like, this has been, we've been addressing this, so I wanted to make
I'll-
it clear to the court.
I'll move on.
well, yeah, I'll just note for the record at this point, without getting into and without making any kind of a credibility determination, because I think Mr. Deloach is now almost kind of putting himself in as a witness, and I think that opens up a complication we may not need to go into, but I take both parties' points. We'll see if it becomes something that is material to the decision here.
Well, Mr. Ghazi, let me ask you what seems to me to be a very obvious question. If you know how important earnest money is, and you had Mr. Reynolds' wiring instructions from before, and you're the one who wants this extension, why did you not wire the money to him rather than just drop a check in the mail?
Well, I was jet lagged. I just gotten back and it was a Sunday when I mailed it and I wanted to get it out of the way. I slept for maybe 2 or 3 days after that. I don't know if you've gone overseas much, but you know, it kind of throws your time scale off.
You didn't call Gene to tell him you dropped a check in the mail.
I don't remember.
You didn't text Gene to tell him you dropped a check in the mail.
I don't remember what I did, to be honest with you. It's been so long.
Is there a text that you haven't produced in this case that?
I produced all the texts between Gene and I, so if it's not in there, then I did not text him.
You didn't send him an email to say the check is in the mail.
I don't recall.
Now, when you wired money initially, you texted like the next day and said, just want to let you know I've wired the money, didn't you?
Yes, sir.
And you followed up maybe a day later, I think, in the text we see where you wanted to make sure you had it, right?
Yes, sir. It was actually, it looks like 4 days later, but yeah, I followed up.
You never followed up with him on this check that you claim you sent.
No, sir, I did not.
Now, we focused a lot on the $10,000 earnest money. Look again at the next to last page of Plaintiff's Exhibit 1 there, the first page of the amendment to the agreement. See that?
I'm sorry, the next to last or last?
Sorry. It's the one up at the top that says amendment to agreement, amendment number.
Yes, sir.
1. Now, you see where it's typed in, like added in bullet points 1 and 2, and bullet point 2 talks about the earnest money, correct?
Yes.
Okay, but look above that at the printed portion of the form where it says, what does that say? Read that now, therefore.
Now, therefore, in consideration, the sum of $10 or other valuable considerations paid by each to the other, the receipts and sufficiency are hereby acknowledged, and the parties agree to modify and amend the aforementioned agreement as follows.
Okay. Did you send the $10 for consideration?
I sent $10,000.
My question was, did you send the $10?
I sent $10,000. I sent more than $10.
Now, again, Mr. Gazi, just to go back a couple of things, these title objections that you raised, I believe I understood Mr. Deloach to say in his opening, and I know this isn't evidence, but I'm going to ask you to see if we can get it into evidence, is that you may well have gone ahead and bought the property even without curing these title objections that were later raised.
Well, it depends on which ones they addressed. There was 3 of them, you know, 2 of them I could have probably lived with, but I just was never given the opportunity or response to close.
Okay, which 2 could you have lived with?
Probably the DOT easement. The other one I'd have to think about. The subdividing was a big deal because it made the financing of the property. It made it unfinanceable, meaning that if I ever wanted to sell in the future, far less buyers could buy it, which that was a really big deal.
Okay, so the DOT easement, let's talk about that one. Do you understand that was an easement for a bridge that had been built across the creek that ran through your property up at the very northern end?
I didn't know. I was taking advice from my counsel.
Did you ever look to see where that easement was?
I was taking advice of my counsel, what they told me how I should proceed.
And I appreciate that. It's good to take advice from counsel, but I'm asking personally, did you ever look?
Did I ever look? I mean,
Where the DOT easement was?
I looked on some GIS maps,
Okay.
but I don't recall exactly where it was. I knew it shaved off some acreage off the property and that the legal description was incorrect. So, you know, it was represented as 50 acres and it was less than that because of that.
In fact, the tax map shows it as, let's see. show you what we've marked as Plaintiff's Exhibit 10, Mr. Ghazi, and ask you if you have ever seen that.
I don't remember seeing this.
You know what Q Public is?
Yes,
Okay. You know that,
sure.
Q Public to be, it to be a publicly available source of information from tax assessors around the state.
Yes, sir.
And you can look up your house on there today and see what the county shows the acreage to be, right?
Yes, sir.
Okay. And you can do that for any property in Georgia as far as you know.
Yes, sir.
Okay. So if the Q Public shows that it's 49.73, or that's what your closing attorney found as opposed to 50, again, you could have known that well before this letter went out about the title pitch.
I didn't look at it.
You didn't, but you could have.
I could have,
All right.
but that's why I pay my attorney to look at.
Gazi, I'm going to show you now that we've marked this Plaintiff's Exhibit 6. Ask you and
Okay. Yeah, it's a text that my wife sent me.
and if you go on through, can you just kind of look and see if there are other texts there?
Sure.
As the third page and text that you sent to Gene Reynolds.
Yes, sir.
Your Honor, I would move to admit Plaintiff's Exhibit 6 and then.
No objection, Your Honor.
Q6 is admitted. Thank you.
Mr. Gazi, I'm not the court that obviously read this, we just have to go through it.
Yeah.
But can you just tell the court what happened on Tuesday morning about 7:24 a.m. on October 19th?
Well, my wife is mostly deaf from childhood cancer, and she had an issue with the gun range we found out was on the property, and I was hoping for a termination to Gene, and I text Gene this text, and I also took a screenshot of my wife's text.
Okay. So no doubt that in your words to Gene, she was pissed at you, right?
Yes.
She wasn't mad at Gene, was she?
No, sir.
In fact, she asked you to apologize to Gene and Julie and hope that y'all could work with them again.
Yes, sir.
So she didn't believe that Gene had done anything wrong in trying to cover up a shooting range in the area.
I don't know what she was thinking. She was angry. This is clearly an impulsive text. I forwarded along, and I was hoping for a termination.
And in fact, you on page 3, you sent this text to Gene. I'm sorry, we're going to have to walk and forfeit the EM. Sarah is pissed at me. That's your text to Gene.
That is my text to Gene, yes.
All right. So as of that moment, Mr. Gazi, you had no intention of buying this property, did you?
No, I was hoping for a mutual termination, and I was telling him that I wanted to walk away from the deal. But as you know, with real estate transactions, deals need to be terminated whether you go through it or not. And this is a text message, an impulsive text message at 7 a.m.
But you knew the import of this text message, didn't you?
Yeah, I was hoping for a termination.
You knew that you wanted to walk away from the deal, correct?
I was asking to walk away from the deal, correct?
Okay. And you knew that if you walked away from the deal, you would forfeit the earnest money.
Correct.
Okay.
But this is pretty much the last communication where we got any response. Everybody kind of went dark. I'd reached out several times, asking about closing, asking if they were going to respond. I reached out to the sellers to ask them if they were going to respond. I tried very, very hard in writing, which is in discovery, to close on this deal or to see if they were going to fix the objection so we can close, but I was never given the opportunity.
All right.
And I communicated via all the methods that are in the contract.
Okay. And Mr. Ghazi, well, I asked you, I think my question actually was, you knew the importance of this email, correct?
This is a text. Yeah,
Or the
yeah.
text? Yes, the text.
Yeah, I was hoping for termination. I mean, I don't know how many times you want me to say it.
Right.
A text isn't a termination of a contract.
And in fact, we already discussed this. You never raised any title issues prior to sending the, well, let me back up. You never raised any title issues between September 3rd and October 15th.
After I was hoping for a termination, I'd asked my company for a title report and I'd gotten it at that point, which I reviewed it.
Your Honor, I'm going to object to the responsiveness of his answer and ask that to be stricken. I'm just asking a very simple question.
All right, so Mr. Gazi, if you could just listen to the question asked and answer only
Okay.
that question.
All right.
All right? If you could
Sorry
about
re-ask
that.
the question, Mr. Jones.
Mr. Ghazi, between September 3rd and October 15th, you never raised any title objections.
No, I did not.
Okay. Between October 15th and the date of this text to Gene, October 19th, you never raised any title objections.
I did not. I was traveling.
So it was only after some time after this that you finally raised these title objections.
It was after, yes.
Yes. And that was not through your initial attorney, Southeastern Closings.
Yes, because I had asked them for the title report. They gave it to me. They found no issues, so I fired them. And since I've never used them since.
And it was only after you hired the second attorney that you raised these objections.
Well, I looked at the title report from my understanding and saw issues with it, and I found another attorney to look at it. Correct.
And as I understand it, the only issue that you think really would have been a problem for you would have been the subdivision into less than 5 acres.
I'd have to think about it. I wasn't given the opportunity with any responses to any of the three. I might have been okay with all three. I don't know. No one ever gave me the option or discussed it with me.
And as we sit here today, you might have been okay with all three.
I don't know. Maybe.
Okay. All right.
The subdivision one was the biggest thing I was not okay with. But the other two, maybe yes, maybe not. I don't know. I would have continued to talk to with counsel and looked at the marketability of the property and made sure that it didn't hamper the valuation of it, which was the biggest thing.
Well, you were looking for a larger property for yourself, right?
No, I was looking for a rental property to rent out, and we discussed with Gene as an Airbnb and something we could also use for ourselves. All my properties that I own, except my primary residence, are all rental properties.
Okay.
I don't own any leisure properties.
All right. Well, let me ask it this way then, and maybe this will clarify it.
Okay.
You've got a home in Atlanta, which is, I don't know where it is or where it's located, but some sort of city-sized lot, right?
Sure.
Okay. You were looking for larger properties in rural areas at this time when this deal was going down, correct?
I was looking for, more of like recreational land.
Okay.
Correct.
All right. Acreage.
Not necessarily acreage. I mean, I looked at a 500-acre property with them and a 50-acre property.
Okay.
It was more recreation and, what I could get the best return on investment.
Okay.
I'm an investor.
But again, you're not looking for a lot in a subdivision to buy a house, build a house.
I'm not, no.
I mean, this deal was not that.
No, I wasn't trying to build a subdivision.
All right. All right. Your Honor, may I have just a minute?
I need more desk space.
Your Honor, I'm just trying to confirm my exhibits here.
The only one I don't see admitted is P10.
And I'm not going to try to admit that one, Your Honor.
I don't believe I have P4.
I don't.
Yeah,
think so
not
either.
before either. 1 through 8.
I don't think I'm gonna use that one, just, if you don't mind, give me just a moment. Yeah, I appreciate it, Jim. I'm not gonna use P4 right now, at least. So, Your Honor, I would show that we have 1, 2, 3, 5, 6, 7, and 8 currently in.
All right, yes, but from my notes, as best I can tell, that's accurate.
All right. Your Honor, I don't have any further questions for Mr. Ghazi at this time. I obviously may have some others after Mr. Deloach examines him on direct. I'm not sure if he's going to do that now or later, but I'm finished for now.
All right, Mr. Deloach.
Your Honor, I have some exhibits to put in. I don't know, different courts prefer this differently. Some don't like it during the plaintiff's case in chief for me to put up all of my evidence. I'm happy to do it now, or I can call Mr. Gazi later. It's really up to the court's discretion, Your Honor.
Mr. Johnson, do you have any preference?
I really don't, Your Honor.
Okay. It seems to me probably most efficient just to do it all at once while he's here on the stand. So
Thank
why
you,
don't
Your
we
Honor.
just
Be glad to
proceed
do it,
from
then.
there?
Whoops. Ms. Sue, I'll be able to screen share if I chose to do that. Is that right?
Yes.
Thank you. Mr. Gazi, I believe we covered sort of your background in the cross-examination. Do you have some experience investing in real estate?
Yes, sir.
Okay. And are you the owner of single-purpose LLCs that own real estate for investment purposes?
Yeah.
How many investment properties do you currently have through single-purpose LLCs?
8.
Okay. And
Some of them have partners too. So
Okay.
I don't, if you say single, I don't want to intend or imply that it's just me on all of them.
um, y- how did you first meet Jim Reynolds?
A friend of mine introduced me and said I was looking for some investment property down, just some farmland with a house on it. And he introduced me to Gene, and I reached out to Gene and told him I was looking for some various properties and asked if he could assist.
And in your prior testimony, you indicated you looked at multiple properties. Is that right?
With Gene, I looked at 2, but I probably looked at dozen plus properties on my own.
And you were asked a question about this being a cash closing. Did you understand that this particular contract anticipated you closing this transaction with the cash payment?
Yes,
Okay. Did you ever consider financing the property?
I did. Initially, I reached out immediately to a couple of a bank and a broker that I've closed, 10 or so properties with, and they'd looked at it and they said I'd have to break off. They told me I couldn't finance it, so I was intending to proceed as cash, but later I found out I'd have to subdivide it a certain way to be able to make it financeable or do a traditional bank.
And in fact, did you actually, if we look at plaintiff's exhibit number 3, do you still have it in front of you?
Yes, sir.
If we look at the second page of plaintiff's exhibit 3,
Uh-huh.
on September 7th, did you text Mr. Reynolds and let him know that you were communicating with a lender that was asking for comparable sales?
Yes.
And I believe you addressed this on cross-examination already, but do you have a history of refinancing properties after you purchased them?
Yes, 100% of my properties I've bought with cash, I've refinanced out. That would have been the intention with this one as well.
Okay.
I think I've done at least 5 cash out refis.
If we look at plaintiff's exhibit, well, let me ask this. Did you and Sarah go to Europe with an intent to elope?
Yes.
Was that a bit of a whirlwind at that point in time in your life?
It was an impulsive decision to elope. We were looking at doing a traditional wedding, and we just decided to elope just to make things easier. So yeah, it was a crazy time for sure.
Okay. Were at the point in time that you chose to go to Italy to get married, were you thinking about the fact that you had a closing scheduled for this property on October 15th?
It didn't cross my mind, no.
If we look at plaintiff's exhibit 5 that was admitted into evidence, you testified about this being a text message from your wife, Sarah, to Bobby. My question is, why was Sarah texting Mr. Reynolds on your behalf?
I was having issues with my phone, and she had his information.
In the text message, she indicates that that you need more time to get the money together.
Yes, sir.
Did you in fact have the money at this point in time available in any location to close on the transaction?
Yeah, the majority of it was in cash, stocks, and mostly bonds, stocks and bonds. I was trying to liquidate them at the opportune time.
And you can stack up those the plaintiff's exhibits
I gotcha.
in one place just to keep them all together.
Yeah. Just trying to have quick access here. Okay.
Okay, I've handed you what I've marked as Exhibit D1. Do you recognize this email on October 14th, 2021?
Yeah, that was the extension email.
Okay. Your Honor, move to admit Exhibit D1.
No objection, Your Honor.
D1 is admitted.
So, Mr. Gazi, did Mr. Reynolds email you seeking an electronic signature on the extension?
Yes,
At the point in time that he emailed you, had he advised you that the sellers had agreed to the extension?
he did.
And he had prepared the extension on behalf of the sellers and you?
Yes, sir.
And you've already testified that you electronically signed the extension that's attached to Exhibit P1, correct?
Yes.
What was the new closing date after everyone signed the extension? You can look at Exhibit P1.
I want to say November 12th, but let me confirm that. Yeah, November 12th, Friday, November 12th.
Okay. And that became, was it your understanding that that became the new closing date as of the point in time that all of the parties signed the amendment?
Yeah, once it got fully executed, correct.
And when were you to make the additional earnest money payment under the terms of that amendment?
5 days, it said.
Did you do anything to pay the earnest money?
I mailed a check.
Okay. And do you know what date you mailed the check?
I believe it was the Sunday after we got back. I believe we got back from Europe on a Saturday or a Friday. I'm not sure exactly when, but it was right when we got back.
Okay. And why did you choose to mail the check on that Sunday?
Just because I didn't want it to be late and I was going to be out of pocket for a couple of days getting readjusted from jet lag.
And I don't want to belabor this discussion because we had communication about this. At some point in time after we had searched for discovery in this case and after your deposition, in preparation for trial, did you discover any evidence of you writing that check?
Just the check stub. Yes, sir.
Okay.
Let me clarify something on that point. Do you recall the approximate date of that weekend you would have returned from the trip?
I believe the check was on the 17th, and I think I got back on the 16th, which I believe was a Saturday. I have to double check the exact date we returned, but it was a Saturday we returned, and it was the next day.
And so you were confident they'd receive it in the mail in 2 days?
I'm sorry?
And so that would have given them 2 days to receive it, right? Through the mail?
I mean, I was hoping it would get there pretty quick. It was a Peachtree address or Peachtree City address, I believe, but figured the date of the check was sufficient for the timing.
I'll need you what if the 11th.
Yeah, the 17th is correct.
Just to be perfectly clear, what is Exhibit D11?
A check stub.
Okay. And was this check stub something that you found in your business records?
Correct.
Okay. When do you believe this check stub was completed by you?
Completed?
When did you fill this out?
On the date, on the 17th. And that day I couldn't send a wire because it was a weekend too, so.
Your Honor, we moved to admit it. I understand, look, I've already explained. The reason for my explanation, Your Honor, was because under the discovery rules, I certainly feel like I had an obligation to supplement it, and I failed to do it. I just dropped the ball on it. I own that. Whether the court considers it or not, I ultimately don't think it really matters. I don't think the fact, our position, our legal position in the case is, it does not matter. But for a complete record, I wanted to at least submit it. So.
All right. Mr. Johnson, any position of the plaintiff on the
Or I would
admission of
have to object.
D11?
Yes, sir, I'm sorry. I would have to object to that, just as having not ever been introduced in discovery, even prior to the last time we were ready for trial. And I understand, thank you, Jeff. I understand things happen in law offices and certainly no disparagement to Mr. Deloach, but I'm going to have to object to it since it was not produced until yesterday afternoon. And I really didn't even see it until this morning when I checked my email. I wasn't working yesterday.
All right. And generally, that would be something that would be made by, I guess, written motion in advance of trial. But you're saying you got that through email this morning,
Yes,
right?
Your Honor.
Okay. All right. Well, I'll conditionally admit it. Note the objection. It's preserved for the record, and I'll reserve ruling on its its exclusion as a sanction under the Civil Practice Act until we see where the evidence takes us.
Sure, Your Honor. And again, well, I've stated my position,
I
Your
don't
Honor.
think
We
we
think
need
it's
to
I
belabor the
think it's
point.
ultimately not relevant. And I don't know if it makes, truthfully, if it makes it easier, maybe I'll just withdraw the effort to admit it, Your Honor. I think that may make it even cleaner. I will not seek to admit it. And that, I think that makes it even, he can testify about what he found regardless of whether the document itself is admitted. So
All right. Well, if that's what you'd like to do, then we'll
I'll do that, Your
instead. So
Honor.
D11 is not.
Yeah, I withdraw it. Uh, do you know the check number of the check that you placed in the mail?
Check 1043.
Okay. Has that check ever cleared your account?
No, sir.
Um, did you, um, do you have any idea what happened to the earnest money check after you placed it in the mail?
No, it was never returned to me. Excuse me.
Did,
How was it mailed?
Just U.S. mail.
They're not open
With
on
a
Sunday
forever
either, though,
stamp.
right?
I'm sorry?
They weren't open that Sunday either.
No, I just put it in my mailbox with the flag up.
did Gene Reynolds or anyone at his company ever contact you and tell you that they did not receive the earnest money check?
No. From his emails, he implied they had it.
Let's look at Exhibit P6. Do you still have that stack of?
Yeah, I got it.
Okay. This is the exhibit that you already testified about, where you forwarded a screenshot of the text you received from Sarah,
Yes, sir.
and you've testified about your statement
Mhm.
to Mr. Reynolds already. For purposes of clarity, what were you intending when you texted Mr. Reynolds, Gene, I'm sorry, we're going to have to walk away and forfeit EM. Sarah is pissed at me.
I was hoping for a mutual termination. You know, that's what was the intention of the text.
Did Mr. Reynolds respond to your text?
He never responded to that text.
What is the next text after your text on October 19th?
The October 29th? You mean the October 29th text?
Yes.
Yeah, that was me calling him to discuss, and he just sent me to voicemail. He was
What-
always busy when we called. He'd always clear me to voicemail. A couple of times he said he's with clients or something like that.
What do you recall happening next after you? Well, let me just ask it this way. What did you do next after you sent this text and received no response from Mr. Reynolds?
Well, I'm sorry. What do you?
Sure. So
Clarify that, yeah.
this text on October 19th, we just
Uh-huh.
looked at it. What did you do next after not receiving any response from Mr. Reynolds?
Well, I started, looking closer at everything and making sure I had all my ducks in a row. And I reached out to the closing attorney and asked them for the title report so I could review it and just, looking at my options if I did close with cash and how I'd get my money back out.
Okay.
And that's when I found some issues with it and I passed it on to a different attorney.
All right.
I had actually reached out to the attorney, asked them why they didn't see this on there. And I don't remember what their response was, but that's when I went and had someone else look at it.
All right. And when you say someone else, you hired another attorney, is that?
Yes. More thorough attorney. Thanks.
I've handed you what's been marked as Exhibit D9. Do you recognize the email and the letter attached to the email?
Yes.
Okay. Is this an email from Mr. Reynolds to you dated October 21st, 2021?
Yes, sir.
Okay. Your Honor, move to admit Exhibit D9.
No objection, Your Honor.
D9 is admitted.
Mr. Ghazi, there is a letter attached
Mhm.
sent to you via email. If we look at that letter, did this letter indicate anywhere that your earnest money had not been, your second earnest money deposit had not been received?
No, it does not. It also refers to the seller retaining the total 20,000, implying that they had it, as well as asking me if I wanted to proceed with termination or not.
So,
You have a copy for me?
yes, Your Honor. In fact, I'll just give you this.
Thank you.
Yes.
Oh, yeah.
So, did this letter let you know how the sellers felt about a mutual termination?
Give me a moment.
Sure.
He said the sellers were not pleased.
Okay. What did Mr. Reynolds indicate to you what would need to happen next if you still wanted to move forward with the termination?
He reiterated that we were closing on the closing date of November 12th, and he asked me if I intended to terminate, to let him know so that he would draw up the termination documents
Okay.
on the last page.
Did you ever ask him to draw up termination documents?
I did not. I was still, trying to move forward with getting answers to the the title objections. I never formally asked for a termination until the closing date had passed.
Did Mr. Reynolds or anyone else on behalf of his company ever present a proposed termination agreement to
No,
you?
sir.
Did you ever send a written notice signed by you to Mr. Reynolds' company or the sellers indicating that you were terminating the purchase contract until after November 12th, 2021?
No, I did not.
Ooh.
Yes, you did. It's already been admitted.
All right, thank you, Your Honor. Handed you what's been marked as Exhibit D3.
Mhm.
What is this?
This is my new attorney reaching out to Jean about some issues with the title that she went over with me and, described in layman's terms so I could understand exactly what they meant.
Okay. Before asking any more, Your Honor, move to admit Exhibit D3.
Objection to D3.
No objection, Your Honor.
And can you state again what this was? Oh, okay, thank you.
But yeah, the Exhibit D3 is the letter from Defendant's Counsel, Ms. Shortridge, emailed to the plaintiff. Mr. Gazi, did you ever receive any response from Mr. Reynolds' company or the sellers to the title objections in this letter from your attorney we've entered into evidence as Exhibit D3?
No response. No. Cool.
Mr. Gazi, I've handed you what I've marked as Exhibit D4. Do you recognize it?
Yes, sir.
What is it?
It was a letter I got a few days after my counsel reached out from Mr. Reynolds' attorney asking for commission, not about closing.
Your Honor, we moved to admit Exhibit D4.
No objection.
D4 is admitted.
Got a copy for Your Honor.
Thank you.
Do you recall approximately when you received the letter marked as Exhibit D4?
Probably a few days after the date on the letter. I think they sent it certified mail.
Okay. Did this letter advise you that they had not received your earnest money check?
It did not.
Did this letter demand that you close on the transaction?
No, sir.
At the point in time that you received this letter demanding payment of brokerage fees, had you terminated the contract?
No, sir. The contract was still in place as well as it was still pending on Zillow all the way until they passed right until the extension, believe it or not. Something like that.
Mr. Ghazi, I'm handing you what's been marked as Exhibit D5. Do you recognize it?
Yeah, I'm just gonna read it real quick. if you
Sure,
don't
take
mind.
your time.
Yeah, I recognize this.
What is Exhibit D5?
It's a letter demanding commission from Gene.
Is it an email from Mr. Reynolds?
It is.
Okay.
It's a message from Gene copying his attorney and his assistant Julie.
Your Honor, move to admit Exhibit D5.
Any objection to D5?
I'm sorry, no objection.
Admitted.
All right, got a copy of it for you. Mr. Ghazi, this email mentions, still looking at D5.
Yes, sir.
This email from Mr. Reynolds to you mentions something about a call from you to the sellers. Did you try to speak with any of the sellers of this property?
Yeah, we tried multiple times to call Gene, and I'd emailed him, I called him, no response. So we found we looked up the seller's phone number. We tried contacting them to ask them if were going to respond to the title issues and if they were going to fix them. And We got in touch with one of the sellers and he kind of cussed us out and hung up.
Did any of the sellers ever respond to your efforts to find out whether they were going to even respond to your title objections?
The only communication with the seller was that one call and it was very brief.
Did the email here marked as Exhibit D5 on November 4th, in this email, did Mr. Reynolds indicate that you were required to close on the sale of the contract?
No,
Did he indicate that your earnest money had not been received?
no.
Mr. Ghazi, I'm handing you what I've marked as Exhibit D6. Do you recognize this email and the attached letter?
Yes, this was once I got the letter from or that letter from his counsel that was certified mail. This was my attorney responding to his counsel as requested about the title objections.
I removed it mid Exhibit D6.
No objection.
D6 is submitted.
You're copied on this email from your attorney, Ms. Shortridge, to
Yes.
the attorney for the plaintiffs. Why did you ask Ms. Shortridge to send this letter on your behalf?
Give me a moment. Let me just read it again.
Sure.
I believe she was just giving, sending the same documentation she sent over to Gene to his attorney, just to make sure that every party had a copy of the objections in a timely manner. And based on what communication methods were in the contract and on also the legal letter received from his counsel.
Up till this point in time, the date of her letter, which is November 11th, had y'all heard anything at all from the plaintiff or from the sellers in response to your title objections?
No, but we did continue to reach out to Gene to try to just get a status or some kind of communication.
All right. And if we look at Exhibit D6, if we look at the email exchange on the front, actually it's on the second page. Did you in fact email Mr. Reynolds yourself on November 12th?
I did. I emailed him and asked him just to see where we were at.
Did you get a response to that email?
I did not.
Did you have the funds available and ready to close on November 12th if the sellers had addressed your title objections?
Yes, sir.
Would you have considered purchasing the property even if the sellers had not cured the title objections raised in Ms. Shortridge's letter?
Yes.
Were you ever given the opportunity to make a choice about whether or not to close on the property?
No, I mean, they just went completely dark.
And what's marked as Exhibit D7. Do you recognize this email?
Yes.
What is this?
Me asking the status of the emails and questions I've asked, trying to see if they're fixing it and if we're going to close.
Move to admit Exhibit D7, Your Honor.
No objection, Your Honor.
D7 is admitted.
Mr. Ghazi, did you get a response to the email that you sent on November 12th to Mr. Reynolds that says, hey, are you guys fixing this? I've not heard anything.
No response. That was also, I believe, the day I texted him and asked him about the closing. Thanks.
Handed you what I've marked as Exhibit D8. Do you recognize this email with the attached letter?
Yes.
Okay. What is it?
A few days after the closing, after not hearing anything back, we're requesting our earnest money back.
Okay. Is this a letter sent on your behalf from your counsel?
That is correct.
Your Honor, move to admit Exhibit D8.
No objection, Your Honor.
Yeah, it's admitted.
Mr. Gazi, this email sent on November 15th, 2021 on your behalf. Did Mr. Reynolds, the plaintiff, or the sellers ever respond to you or Ms. Shortridge as to your request for the earnest money?
No.
Since November 15th, 2021, the date of this letter, has Mr. Reynolds or his company sent you anything in writing indicating what it intended to do or wanted to do with the $10,000 earnest money that it's currently holding?
I believe the next communication was when I got the lawsuit a year later.
And did it address the earnest money?
I don't remember.
Mr. Gazi, Mr. Reynolds' company's brought this lawsuit against you to collect a real estate commission that it claims that you owe him. Do you believe that you owe Mr. Reynolds or his company anything at this point in time?
No,
And why or why not?
because I was never given the opportunity to close. I mean, you get a commission when a deal closes, and I was never given the opportunity despite multiple efforts in writing to try to close or ask, status of title objections.
No further questions, Your Honor.
All right, Mr. Johnson, how much time do you need for any re-questioning?
I really don't know that I have anything else, Your Honor. I think it's all been fairly well covered with Mr. Gazi. So,
If you need to
Yeah,
take a
I'll-
minute to confirm that, feel free, and then we can break for lunch.
okay.
What do I do with all this? Just leave it?
Just hang on that tight for just a
Okay,
second.
cool.
The court reporter will want to gather that.
Your Honor, I don't have any
Thanks.
further questions for this witness. So,
All right, Mr. Gazi, you can step down then.
Okay.
You can return to council table. If we could just gather the exhibits, make sure they're in order and provide those to the court reporter.
Thank you.
Mr. Deloach, you can have back your copy of P1. I think I've already got one now.
Yes, Your Honor. Thank you.
All right. So, Mr. Johnson, any preference on how long you want to break before we come back, and you can call any further witnesses or present any further evidence you have?
I mean, Your Honor, if we could be back by 1 o'clock, I think we'd be fine. I mean, that gives us nearly an hour, but Jeff, you gotta.
Does that work for you?
Good with that?
Sure. Yes, Your Honor.
Okay, then that's what we'll plan to do, is to be back at 1 o'clock. Let me. We can, I think will we lock the courtroom during that time, Deputy? Okay, all right, so, yeah, we actually have a side room there you may be able to get into if you need to kill time, but otherwise you can be out in the hallway. Just before we break, I want to just kind of inquire again, Mr. Deloche, ask you generally on a legal point here. It's my understanding generally under just kind of the black letter contract law that an anticipatory breach can be done by acts or conduct alone. And I know you've pointed me to the notice provision and the default provision of the original agreement. And so, is your position under the umbrella of this contract in this situation that the only way a party could commit an anticipatory breach would be through formal written notice under the terms of the contract?
Yes, Your Honor. I believe you have to give effect to the contract terms. And there was no mutual departure from the contract terms. There was no modification of the contract terms. There was, as the evidence is, a request to see if a mutual termination could be entered. And subsequent to that, in fact, the plaintiff told him what would have to be done for there to be a termination.
No, I know. I'm more getting into hypothetical territory because I
Okay.
want to understand the
sorry.
guardrails that are in place here. Let's just say at the moment, a text message is sent. I'm getting a little bit into argument here, so just give me some leeway here.
Sure.
The moment a text is sent, is there what provision in the original contract could you point me to that says any breach has to require formal written notice? Just to breach generally has to be done in writing. I mean, can't a party anticipatorily breach through their acts and conduct alone? I get, even under this agreement is what I'm getting at.
I think hypothetically, there's a scenario where there could be an anticipatory breach of a real estate contract. I do not believe the facts in this case would come close to what's required under the law for there to be an anticipatory breach when there is a very specific provision addressing notice and what constitutes notice under the terms of the contract.
But the notice provision just says this is how you provide notice. It has to be in writing. This is what you do. Does it necessarily detail every single point you are supposed to provide notice? Meaning at any point you're going to breach, you have to provide this written notice. Because I'm not seeing something like that in there. So I guess the hypothetical would be as if one of the parties to this just, disappeared entirely.
Correct.
That's, they haven't put anything in writing, but I think by their acts and conduct, the other party could reasonably say, well, I think they're committing an anticipatory breach and there's no reason for me to wait until a month from now to formally decide that.
I would agree under the scenario you just gave, Your Honor, there is a hypothetical scenario where there could be a anticipatory breach.
Okay. And I certainly understand the argument you're making is that, hey, an anticipatory breach can be withdrawn, it can be waived, or it might not even cross that threshold of being an anticipatory breach. But I guess my point is that the lack of it being in writing alone, I don't know if that's enough to prevail on your part. Is that something you'd be willing to concede?
Your Honor, I don't believe there was any act taken in this case that constitutes anticipatory breach.
All right.
I would not concede that there was an act taken, that there's facts and evidence that support an anticipatory breach. All
right, fair enough.
Request to see if there could be a mutual termination.
And we can get further into that when the evidence is closed if we need to. But I appreciate you engaging me on that. All right, so we'll be in a break until 1 o'clock. And there's been some developments in the case. So to the extent a check stub is relevant, or to the extent we're actually seeing it in person here today, this is kind of an all or nothing case. So someone's going to go home unhappy, right? And so if the parties end up coming to terms between now and then, let me know.
Thank you.
All right, thank you all.
Ask one thing about
Yes,
your
sir.
sort of plan for, once we close the evidence. I assume we'll give a closing argument, but then, never having done a bench trial with you like this before, do you anticipate asking us for a proposed order, findings of fact, conclusions of law, or will you take it under advisement? Will you rule? I'm trying to figure out.
I kind of want to see I want to see where the evidence goes. And if kind of is my understanding of contract law and what's come out, that I see a clear path. I don't want to, I want to give you the case has been pending long enough. I want to give you an answer today if I can. And what that answer is, then I would ask the prevailing party for some assistance, and however they want to protect their judgment and the findings of fact or whatever, feel free. If they want to make it a one sentence,
Okay.
have at it. It may very well be that's all that you need, because it's all legal findings of the Court of Appeals review de novo. So what's the point? But we can go from there. Yeah. Anything else?
No, Your Honor.
All right. See you in a little bit.
Thank you, Your Honor.
I'm gonna pack up everything so that we can get it to a conference room and sit and talk for a little bit. And it's kind of a mess here. Oh, wow.
I'm gonna run to the restroom right.
Yeah, you're fine. I'll meet you out there.
All this because or getting everything back in my briefcase is like trying to put the genie back in the body. That's hopefully this is charged up enough if I need it. You have a laptop with you? Okay, all right. Let's see if we can get this same room we had before. This room.
Thank you, Brenda.
Yeah. Okay, all right, cool. I'm heading. Yeah, I'm heading down, I think so.
Kamala Harris is killing the American dream. Kamala Harris claims to support them.
Oh.
What time the judge say he coming back?
One.
One?
Where's the deputy told me earlier, there's a restroom in here somewhere?
Yes, right,
Just right there?
yeah. Yeah. Radio.
Thank you.
He's not.
This little table, huh? It's probably flat. It's okay. Yeah, that's good. Safer.
Come over here.
Hey, how you doing?
How y'all know?
Doing good,
Doing well,
thanks.
sir. How you?
Yeah, yeah. Let's see. There's my phone.
Ah, uh-oh.
Oh,
look at that.
I'm like, man, it's kind of one of those things that you get out and it's like, oh my gosh, where is it?
Right where you left it. That
Yeah, it
always
is right
is.
where I left it.
We have everyone, right?
Yes.
Name is Peter, before we come to water.
Thanks, Joe. Please stay seated. It's fine. All right, let's go back on the record. Anything we need to take up before plaintiff can call their next witness? Mr. Johnson?
Not for me, Your Honor.
Mr. Deloach?
No, Your Honor.
Floor is yours, Mr. Johnson.
There. Yeah, the bailiff will swear you in.
Who are you calling for the record?
This is Gene Reynolds.
You swear affirm that the testimony you give before is the truth and nothing but the truth. Okay? I do. May be seated. Spell your first and last name for the court.
My name's Gene Reynolds, Genereynolds.
Okay, Mr. Reynolds, how are you associated, affiliated with Gene Reynolds Realty?
I'm the broker owner.
Okay, all right. Just give the court a little background as far as your education and experience and things like that. Can we get into the real estate part of this?
Okay. I graduated from high school. I joined the Air Force. Was in the Air Force Security Service with highest security clearance you could get. And after that, I had a couple of jobs going to school and then started real estate
Okay,
in 1989.
all right. So when were you first licensed as an agent?
February 89.
Okay, and when were you first licensed to have your own brokerage?
1999.
As a real estate agent, do you have to take any kind of continuing education courses?
Yes,
Okay, and have you stayed current all that?
yes,
Do you still hold a valid Georgia real estate agent's license
yes,
and a broker's license?
yes.
Okay. When did you first meet Bobby Gazi, the defendant here?
I'm not sure the exact date, but it was prior to doing this contract.
Okay, and I'm not going to reinvent the wheel here. I think the judge has heard most of the evidence here, so I want to kind of get into some specifics with you. Did you originally represent the sellers of the property at 6550 Gay Road?
Yes.
I do. Show you what we had marked as plaintiff's exhibit 9. Mr. Reynolds, identify that.
That's an exclusive seller brokerage engagement with the sellers.
Okay. Your Honor, we would move to admit plaintiff's exhibit 9.
No objection, Your Honor.
B9 admitted.
Your Honor, here's a copy for you as well.
Thank you. Just move that.
Mr. Reynolds, can you explain to the court, generally speaking, what is a seller brokerage engagement agreement?
Basically, it's a contract between the broker and the sellers that allows us to work to get their property sold.
Okay. And does it provide how you will be paid if the property is sold?
Yes.
Okay. Can you find the provision in here that provided how you would be paid if this property were to be sold?
It's on page 2 at the top.
And what does the contract provide for?
Commission of 7% of the sales price.
I want to show you what we've previously marked as plaintiff's exhibit 1. You recognize that it's already in evidence?
Yes, sir.
And what is that?
Purchase and sale agreement for 6550 Gay Road, Gay, Georgia.
Is that the contract where Mr. Ghazi agreed to buy 6550 Gay Road from your seller clients?
Yes, sir.
What is the agreed upon purchase and sale price there?
It's $485,000.
So explain to the court how you would have been paid if this contract closed.
When it closed, we would have been paid a commission of 7% of the sales price.
Okay. Well, we can do the math. Have you actually done the math on that?
I haven't. Normally I don't because that's not what I focus on.
Okay. Well,
I think it's in your complaint. Mr.
it isn't. That's what I was actually looking for, Your Honor. So it's in the record in the complaint. And is that the amount that you are asking Mr. Gazi to pay you today for the commission that you did not receive?
Yes.
Okay. Counsel for Mr. Gazi has made some points about notice under the contract, and obviously the contract speaks for itself. But in the day-to-day operation of real estate, do you find that texts are often used?
I'd say over the last 8 or 10 years, more and more, it's almost standard nowadays.
There's been testimony, Mr. Reynolds, about an extension that is requested by Mr. Gazi. You've heard that,
Correct.
right? You've heard Mr. Gazi testify about earnest money that's to be paid, correct?
Correct.
Let's just be clear for the court. Did you ever receive $10,000 earnest money from Mr. Gazi in connection with the amendment to extend the contract?
No.
Did you ever receive a check?
No.
Did you ever receive a wire?
No.
Did he ever deliver you any cash?
No.
Did you understand that $10,000 should be coming from him?
Yes.
Did he ever follow up with you to see if you received it?
No.
Let's go back to when he originally signed the contract. Did he follow up with you to make sure you received the original $10,000 wire?
We did receive the original, and even it was late compared to what was in the contract.
But once he sent it, did he follow up with you?
Yes.
Text you to make sure you gotten it?
Yes.
Okay. Show you page, I'm sorry, Plaintiff's Exhibit 6 that's already in evidence as well. Ask you to go to the second page. Let's see. Sorry, the third page of that exhibit.
Okay.
Did you receive the text from Mr. Ghazi down at the bottom of the page? That says, Gene, I'm sorry, we're going to have to walk and forth at the EM. Sarah's pissed at me.
Yes, I did.
How did you take that?
I took it as he was walking, he wasn't going to close on the property.
At that point in time, did you have any reason to believe that he was not going to forfeit the earnest money and walk?
No.
You heard testimony earlier, Mr. Reynolds, about the possibility of what we might call a mail-away closing. Is that right?
Yes.
Can you explain to the court what that typically involves?
Normally, there's two ways you can do it. You can either actually mail it or FedEx it, or the closing attorney can email it to the buyer or seller, depending on who it is. And so they would sign it, date it, sign it everywhere's needed, and then send it back to the closing attorney.
Okay. In this particular case, did the sellers come to Atlanta to sign closing documents?
No, one of the sellers lives in Arizona, and the other two live south of Griffin.
Okay. How were their signatures handled on the closing documents?
Now, they were going to close, they were going to sign.
Right.
The closing attorney had emailed it to Mr. Kenny in Arizona, so he had already signed.
I want you to look at Plaintiff's Exhibit 5. Mr. Reynolds. It's only in evidence. And if you will look at the second page there. Is that middle text a text from you back to Sarah Gazi?
Yes,
And what were you telling her at that point?
that the seller had signed, Mr. Kenny, who lives in Arizona, had already signed.
So had that been, again, what we would call a mail away type closing for
Yes,
him?
yes.
Did you offer anything similar to that to to Sarah or to Mr. Bobby Gazi about how they might be able to close?
Well, when they first told me they were in Italy, I was trying to figure out what we could do. So their closing attorney, I talked with them, see if they could do a mail away or email it to them to their hotel in Italy. And so the attorney was in agreement that they could do that. And so that's how we were going to proceed.
Okay.
Objection, Your Honor, that hearsay, object to his.
Mr. Johnson, any response?
Well, I don't want you to say anything that the closing attorney told you, okay? So let me just ask it this way. I'll withdraw the question.
And I move to strike that response. that
All right.
described what the attorney said.
All right, let me just,
Well, I believe we have an email.
yeah, just a minute. Look at page 3 of
Just
Exhibit
again, note for the
5.
record, the objection sustained and the response will not be considered. All right, Mr. Johnson.
Yes, Mr. Reynolds, will you look at the 3rd page of Exhibit 5?
Okay.
Did you email Sarah Ghazi yourself about an idea for how they could close?
Now, email, I don't know.
Did you text her? I'm sorry, text.
Yes.
Okay. What did you text to Sarah?
That we could close with, via email.
Just read that. Why don't you just read that first, just to be clear?
Okay, another idea. How about the closing attorney email and closing package to the hotel in Italy? You all sign and FedEx it back to the closing attorney.
Show you what's been marked as Exhibit P8. Do you remember getting a copy of that email from Mr. Ghazi's closing attorney?
Yes,
Okay. And that document speaks for itself, but just generally speaking, what is that suggesting there?
it's from the closing attorney. It says, "Hi, Bobby, attached or your portion of the closing documents for the sale.
Okay.
Seller will be in the office on Friday to sign their portion."
Okay, all right. Let me ask you this, Mr. Reynolds. In your experience as a real estate agent, would a closing attorney send a package of documents to his client to sign if there were title objections that the attorney knew about?
I've never seen them in 35 years of doing business.
All right. If there were closing or if there were title objections on a property that you were the broker and involved in, would the closing attorney typically let you know that there were title issues?
Normally they'll tell me.
Okay, all right. And did the attorney that was Mr. Ghazi's attorney that he hired ever tell you that there were any title issues with this property?
No.
Okay. I'm going to show you what was marked as Exhibit D9. And look at the last page of that. I want you to read, not just read to yourself, this last paragraph here.
Read it to myself.
Yeah, just read to yourself.
Okay.
now. What, does that paragraph mention what would happen if Mr. Ghazi did not go forward with the sale as regards to earnest money?
Yes,
And what does it say?
they would, for the termination, the closing attorney drop escrow disbursement document stating the seller to retain $20,000, $10,000, which had been deposited. And the second $10,000, which was supposed to have been as outlined in the addendum.
Okay,
To
that
the
last
property.
little bit's what I want you to focus on for the court, okay?
Okay.
Had you received $10,000 back in September when the deal first was inked, first?
We had the first 10,000.
In that email, were you saying, did you mean to say that you had received second $10,000?
No, we were saying the sellers were supposed to receive it as was outlined in the addendum,
Right.
but we never received it.
All right, just want to make sure you're not saying there that you had his extra $10,000.
Right, right.
Mr. Reynolds, we talked about this a little bit earlier. At some point after all of this, did you broker a sale of that same property to another buyer?
It was about 3 months later,
Okay. What did the property sell for?
485.
Is that the price that was anticipated here?
Yes,
Okay. Did those sellers raise, I mean, those buyers raise any title objections?
no. And they also received or paid for title insurance also.
Okay.
I'm gonna object that that's hearsay, that last testimony.
Well,
So noted. That'll be given the weight it deserves. All right.
let me ask you this, Mr. Reynolds. Were you present at that closing?
Yes,
Did you see, were you provided in part of your work as the agent with a copy of the HUD closing settlement statement?
yes, I have it in the file on my desk.
All right. Is there any portion of that then that you contend remains hearsay, Mr. Deloach?
Not those two statements, Your Honor. I still contend, we haven't seen a document. We just don't.
Okay.
And I don't have anybody to cross-examine. I don't know whether there was title insurance, there wasn't, whether there were title, I mean.
Well, based upon your personal knowledge, not what somebody else told you, based upon your personal knowledge, what you saw and observed at the closing, did those buyers get title insurance?
Yes.
All right. Then the objection's overruled.
All right, thank you. Just looking, Your Honor, quite a bit of what I was going to cover with him has already been covered with Mr. Ghazi, so if you'll bear with me. Your Honor, I'll reserve right to redirect, but that's all I have for this witness at this time.
All right. Mr. Deloach.
Thank you, Your Honor. Good afternoon, Mr. Reynolds.
How you doing?
You represented the seller in this contract negotiation with Mr. Gazi, correct?
Yes.
And Mr. Gazi did not have his own realtor or broker representing him.
No.
So you were handling both sides of the transaction.
That's correct.
And you previously told me you refer to Mr. Gazi as a customer while you had a broker's listing agreement with the seller. Is that accurate?
Yes.
And your company drafted the contract that was ultimately signed by Mr. Gazi and the seller that was admitted as Plaintiff's Exhibit 1.
Yes.
After the contract was signed by both parties, Mr. Gazi paid $10,000 of earnest money into your trust account.
Correct.
And we've established the original closing date was October 15th, 2021.
Yes.
Approximately 3 years later, your company is still holding the $10,000 earnest money in your trust account.
That's correct.
You have plans to get one already? It's the contract.
Yep.
All right. If you will, let's flip to the last 2 pages of that, the amendment. You're familiar with the amendment.
Okay.
Your office drafted this amendment for the parties, correct?
That's correct.
And you signed the agreement, the amendment electronically on behalf of your company for both the buyer and the seller.
Yes.
And your office emailed Mr. Ghazi, who signed the amendment electronically.
Yes.
Each of the sellers also signed the amendment, correct?
Yes.
And you or someone in your office filled in the acceptance block at the bottom of the amendment, indicated it was accepted at 6 p.m. on October 14th, 2021.
Yes.
And the amendment says, whereas the undersigned parties desire to amend the aforementioned agreement, it being to the mutual benefit of all parties to do so. Did I read that correctly? Do you see that?
Tell me, which one? First line?
Yeah, it says right here. I'm going to point you to the right place. It says the second whereas. So there's one whereas. Do you see the second whereas?
Yes.
Okay, it says, whereas the undersigned parties desire to amend the aforementioned agreement, it being the mutual benefit of all parties to do so. Did I read that correctly?
Yes.
Okay. And the amendment has 2 numbered terms, correct?
Yes.
The first one says closing shall be extended to Friday, November 12th, 2021.
That's correct.
All right. And number 2 says buyer shall deposit an additional $10,000 in escrow within 5 business days of the full executed extension. Escrow deposit shall be non-refundable and credited to buyer's closing statement at closing. Did I read that correctly?
That's correct.
And you've testified that you never received the additional $10,000 escrow deposit.
Correct.
All right. You don't know whether or not Mr. Gazi placed a check in the mail to you, do you?
I do not.
You never sent any written request to Mr. Gazi asking him the status of the additional deposit, did you?
I don't think we did.
Okay. And you never sent any written request to Mr. Gazi asking him to make the additional deposit under the amendment, did you?
I think we had received the text that they were terminating. And so once we received that, we figured the deal was dead.
Okay, but it's a yes or no question. You never sent any written request to Mr. Gazi asking him for the additional deposit owed under the amendment, did you?
I didn't.
And you're not aware of anyone for the seller asking for it either?
No.
Do you have Exhibit P6 with you already? If not, I can retrieve it for you.
I do.
Okay. You testified a few minutes ago about this text that you received from Mr. Gazi on October 19th. You did not text him back that day, did you?
I don't think I texted him. I think we may have had a phone call, but I'm not sure.
Okay, but you did not text him back after you received that text on October 19th that day, did you?
Not that I know of.
And it's not in Exhibit P6, is it?
No.
And in fact, your next text in the chain that you produced is the next day, is 10 days later on Friday, October 29th, correct? At the bottom of the third page, it's partially cut off. But the text from you on October 29th says, sorry, I can't talk right.
Yeah. Okay.
And then is it fair to say that that probably said, sorry, I can't talk right now?
Yeah.
Okay. So on October 29th, you texted him for some reason that you couldn't talk right now. Wasn't that because he was calling you to try to find out the status of the title objections?
Well, I'm not sure.
He was, in fact, trying to call you, wasn't he? And that's why you responded with this text.
Well, this was a text. Yeah.
Okay. But when you texted on October 29th, sorry, I can't talk right now, that's because he was trying to call you, correct?
Yes.
Okay. Mr. Ghazi never sent a letter or any document signed by him to you or the seller stating he wanted to terminate the contract, did he?
No, just a text.
And in fact, after the text on October 19th, the first thing you received in writing from Mr. Ghazi was an email with an attached letter from his attorney providing the notice of title objections in an effort to close the transaction, correct?
I believe, in our opinion, he was already in default because he hadn't closed on the original contract and he hadn't given the earnest money in order to make the amendment binding.
Okay, so that, I understand, but my question is this. After that October 19th text, the next thing you received in writing from Mr. Ghazi was actually a letter from his attorney noting title objections to be addressed if the matter was to close. Isn't that correct?
Yes.
Okay. And you received that email on October 26th, 2021.
Yes.
I've handed you Exhibit D3, which is that email and attachment from Elizabeth Shortridge, the attorney for Mr. Ghazi. You recognize that, don't you?
Yes.
And you received that email on the 26th. If we flip to the last sentence of her cover email, you see her cover email? The last sentence in that email says, I trust that you will promptly pass this communication along to your client so that we can have a productive discussion. Did I read that correctly?
Yes.
All right. You think that someone at your company forwarded that letter and the enclosures to the seller, right?
Tell me again.
You think someone at your company forwarded the letter and enclosures to the seller, but you don't have an actual record of it, correct?
I don't have a record.
Got it. And you did not respond to the letter from Ms. Shortridge that's marked as Exhibit D3, did you?
I don't think so.
And you don't have any documents indicating anyone on behalf of your company ever responded to the letter from Ms. Shortridge marked as Exhibit D3, do you?
I don't have any documents.
And the sellers did not respond to the title objection letter marked as Exhibit D3, did they?
They did not respond.
Okay. And as far as you are aware, the sellers did not do anything to try to address Mr. Ghazi's title objections.
Their stance was the state had taken that sliver of land right at the bridge. There was nothing they could do about it. I mean, it was already done.
So that's a no. They didn't do anything to try to address or respond to Mr. Ghazi's title objections.
No.
And just a moment ago, I read you that last sentence of the cover email that says, I trust that you will promptly pass this communication along to your client so that we can have a productive discussion. Neither you or anyone else at your company ever responded to the offer to have a discussion with Ms. Shortridge or Mr. Ghazi about closing the transaction, did you?
I don't think so.
And after that, we have the exhibit P6, your text on Friday, October 29th, 3 days later, where you say, sorry, I can't talk, or sorry, I can't talk right now. And you've already testified that's because Mr. Gazi was trying to call you, wasn't he?
I would assume so.
But you wouldn't talk with him, would you?
Not at that moment.
If we look at the last page of exhibit P6, the very last page,
Okay.
that's a text from Mr. Gazi on asking you about the status of closing, correct?
Yes.
In fact, he says, Gene, we have not heard back. Today is closing. Are you guys fixing the title objections? That's what he said, isn't it?
Yeah. I mean, I just see the time. I don't see an actual date on here.
I agree. These are the texts produced to you. I don't have the date either, but he sent this to you.
Okay.
And it's in your text chain that you produced, correct?
Okay.
Is that right?
Yes.
Okay. You didn't respond to that text, did you?
I'm not sure.
You don't have any evidence that you responded, do you?
Right.
I've handed you what's been previously admitted as Exhibit D4. Do you recognize that letter dated October 26th that was sent to Mr. Gazi from attorneys hired on your behalf?
Yes.
It was mailed out, certified mail and regular mail, the same day that you received the email from Ms. Shortridge with title objections, correct?
Yes.
That's October 26th.
Yes.
And in this letter, your attorney makes a demand upon Mr. Gazi to pay your realtor's commission of $33,950.
That's correct.
This letter does not demand that Mr. Gazi deliver $10,000 earnest money that your office had apparently not received.
That's correct.
In fact, the letter does not mention the $10,000 earnest money payment at all, does it?
No.
And it doesn't mention your current theory that the amendment was not valid.
That's why this letter was sent, because they never deposited the second earnest money. So without that earnest money, there was no addendum.
But that letter doesn't mention the earnest money, does it?
Not in this letter.
Okay. And similarly, that letter does not make any demand on Mr. Gazi to close on the purchase of the contract, does it?
No, they'd already told us they weren't closing.
You're referring to the email, or excuse me, the text message that we've looked at several times. Okay. But that's a no. It does not request that he close on the transaction. That letter does not.
No.
That letter is only concerned with collecting your real estate commission, correct?
This letter is, yes.
Handed you what's already been admitted into evidence as Exhibit D5. You recognize that as an email you sent to Bobby Gazi on November 4th, 2021, correct?
Yes.
And like the letter from your attorney This email states that Mr. Ghazi owes you $33,950 in commission, correct?
Correct.
Like the email, like the letter we just looked at from your attorney, the email does not ask Mr. Ghazi to pay the $10,000 earnest money that you indicate wasn't received, does it?
It doesn't.
And the email does not suggest that Mr. Ghazi is obligated to close on the purchase of the property.
It does not.
And the email does not even acknowledge that Mr. Ghazi presented a letter with title objections that could be cured or addressed and he would purchase the property, does it?
No.
I've handed you what's previously been admitted as Exhibit D6. You recognize that email with a letter from Ms. Shortridge, Mr. Ghazi's attorney, dated November 11th, 2021, correct?
Yes.
All right. In the letter, Ms. Shortridge tells your attorney that, quote, closing under the agreement was not October 15th, 2021, but rather the First Amendment extended the closing under the agreement to November 12th, 2021, correct? That's what it says. That's what the letter says, is my question. That's what,
It would be correct, provided they had followed the terms of the contract.
my question is just, that's what Ms. Shortridge's letter says to your attorney,
Yes.
correct?
Yes.
Right. And she also tells your attorney, neither the purchaser nor I have heard any response from the broker or seller with respect to resolving the title objections raised in the title objection letter. That's what it says, right?
Yes.
And no one, you nor the seller, responded to that letter from Ms. Shortridge, emailed on November 11th, 2021, correct?
Not that I know of.
Now, if the sellers had responded and told Mr. Gazi that they would not or could not cure the title objections, Mr. Gazi still could have purchased the property, couldn't he?
He could have.
Handed you what has been previously admitted as Exhibit D7. You recognize that as an email that Mr. Gazi sent to you and your assistant Julie on Friday, November 11th, 2021, correct?
Yes.
And in that email, he actually forwards, again, the email that Ms. Shortridge sent, but he says, Gene, hey guys, are you fixing this? I have not heard anything. Thanks, Bobby. Did I read that correctly?
Yes.
You did not respond to Mr. Gazi's email, did you?
I did not.
You are not aware of Julie or anyone else in your office responding on your behalf, are you?
I wasn't aware.
And you'd agree with me that Mr. Gazi was trying to get some type of response from you, wasn't he?
According to this.
I've handed you what's been previously admitted as Exhibit D8. You recognize this as an email in the attached letter that was sent to you by Ms. Shortridge with a copy going to your attorney Sam Beck on November 15th, 2021, correct?
Yes.
In the second paragraph of the letter, Ms. Shortridge states, seller failed to satisfy any of the objection raised in the title objection letter on or before November 12th, 2021. Furthermore, neither seller nor broker responded to purchaser or me with respect to any of the objections raised in the title objection letter on or before the closing date. Did I read that correctly?
Correct.
And that's a true statement, isn't it?
It is. And I'll have to say, we still hadn't received the 10,000 earnest money, the second 10,000. So therefore, there wasn't an extension, in my opinion.
Okay. In this letter, Ms. Shortridge requests that you return the earnest money, doesn't she?
Yes,
You did not return the unearnest money as requested by Ms. Shortridge, did you?
we did not.
And in fact, you nor your attorney responded in any way to Ms. Shortridge, did you?
I'm not sure if the attorney did. I didn't.
Right? And you don't have any documents indicating your attorney responded on your behalf either, do you?
No.
Thank you.
What about these?
It happened to be
There.
okay, great. You'll take a look at that exhibit P9 for me, please. That's an exhibit that's been previously admitted. This is an email that you sent to Mr. Ghazi 2 days after the text on October 19th. It's exhibit P6 where he says, I'm sorry, we're going to have to walk away, right? So this is an email you sent to him 2 days later, correct?
Yes.
And in this email, you indicate that he had, you say, we received a text message requesting to terminate the contract. Did I read that right?
Yes.
Okay. And then if we look at the second page of your letter, there's a paragraph that starts out lastly.
Yeah. Okay.
You say, if you wish to move forward with the termination, we will reach out to all parties, including the closing attorney, to draw up escrow disbursement documents stating the seller shall retain $20,000 deposit, $10,000 from execution of purchase and sale agreement, and the second $10,000 deposit outlined in the fully executed addendum. Did I read that correctly?
Yes.
So after you email him this letter on October 21st saying, if you wish to move forward with termination, Mr. Gazi did not respond to you to tell you he still wanted to terminate, did he?
I don't think so. I don't know.
You don't have anything indicating that he did, do you?
No.
And you never presented Mr. Ghazi with the proposed termination document or the escrow disbursement documents you describe in this letter you sent him on October 21st, did you?
I didn't.
You remained the listing broker for this property after Mr. Ghazi's counsel actually did terminate the contract on November 15th, 2021, didn't you?
Yes.
And in January of 2022, approximately 2 months after the final letter from Mr. Ghazi's attorney, the same property was purchased by Joseph and Kelly Williams, correct?
Correct.
And your company received 7% commission on the purchase of the $485,000 contract.
That's correct. Which we had done the work for.
Sure. And your effort to pursue Mr. Ghazi, even before he signed any formal notice of termination, meant you had a chance to earn twice the commission on one property, didn't it?
No, I mean, he had time, he had a contract, he could have closed. Everybody worked in good faith, except your client.
Okay.
We never got an earnest money that was agreed on, which without that earnest money, that means he had no extension.
I understand it is your legal position that without the earnest money, there's no extension. But you actually didn't put that in any of your letters to him, did you?
I think we talked about it, yeah.
You talked about it with him?
Yeah.
Okay, but it's not in writing, is it?
No.
Okay. And in fact, to be clear, when you demanded earnest money from him, you knew you could sell the property again and actually get twice the commission on one listing agreement, didn't you?
That never crossed my mind.
Okay.
But
all right. Fair enough.
it doesn't,
Fair enough. I have no further questions.
Any additional redirect? Mr.
Yes, a
Johnson?
couple, Your Honor. Gene, just to follow up on that last point that Mr. Deloach raised, were you trying to set this up all along to get a double commission out of this property?
no. Well, I would have been totally happy to close with Mr. Gazi if he'd have performed per the contract.
Mr. Deloach read from the amendment a couple of phrases. Let me ask you this. Did the sellers ask for the extension?
No.
Was that just Mr. Gazi?
Yes.
Was the extension of any benefit to the sellers?
No.
They need extra time to close?
No.
Mr. Deloach questioned you multiple times about, did you ever reach out to Mr. Gazi to see if he'd sent the additional $10,000 earnest money? Did he ever reach out to you to see if you'd gotten it?
No.
Seems a little awkward to say or odd to say, but is a text written?
Yes.
I don't have anything else. Thank you.
We cross on those points only.
Very brief. You just stated, I wrote it down to make sure I got it right. You were totally happy to close with Mr. Gazi if he would complete the contract, right?
Perform on the contract that we had.
But from October 26th to November 12th, when he and his counsel were trying to reach you and the sellers, you all never responded, did you?
At that point, he had never provided the second earnest money per
So-
the contract.
So that's a yes. You never responded to his efforts between October 26th and November 12th.
Between the text they sent that they were out,
My question is a yes or no.
no.
Thank you.
Nothing further, Your Honor.
All right, can this witness step down? Thank you, Mr. Reynolds. Why don't we'll have Mr. Johnson organize that and provide to the court reporter.
Sorry, the exhibits.
Exhibits.
Yes.
Yeah. And I can pull the defense exhibits back together.
All right, Mr. Johnson, any additional evidence on behalf of the plaintiff?
No, Your Honor, the plaintiff rests.
All right, Mr. Deloche, you need to make any motions to be preserved for the record?
No, Your Honor, I'm not going to make any mid-trial motions. We think the court's going to have all the evidence and can decide it.
All right, fair enough. Then turning over to the defense, any evidence on behalf of the defense?
Yes, Your Honor. I've obviously submitted a number of exhibits. I do need to state my place, the attorney's fees, Your Honor. And I'm not going to.
All right, we can reopen the evidence for the plaintiff.
I'm sorry.
Yeah.
All right, any additional evidence on behalf of the plaintiff if we reopen
Yes,
it?
Your Honor, I need to tender plaintiff's exhibit 11. I'm sorry. This is the documents that we previously provided. Any objection?
No.
Okay, thank you, Jeff.
Sure.
Plaintiff's exhibit 11, Your Honor, is my attorney's fees.
All right, any objection to plaintiff's exhibit 11?
None, Your Honor.
All right, submitted without objection, and this is what is I suppose like the itemized statement of all the work you've
Yes.
done on this case up to today.
Yes, Your Honor, this is actually through, I'll state my place, Your Honor, Burke Johnson, been admitted to the bar since 1987, so 37 years doing this. My hourly rate, I'm on an hourly rate contract, a fee contract with Mr. Reynolds. My hourly rate is $350 per hour, which I believe is appropriate and reasonable for someone with experience and background. And yes, we have, as we do with all of our clients, we send monthly invoices itemized out for billing on our cases. And this, we went through and, tried to make sure everything was appropriate and correct. The last bill that we had prior to the trial date back in May that we were set for, the last of this is through April 30th. And I have not really done much other than some preparation this last week or so, a day or so maybe, and then today for the trial. I don't have an exact number on that. I'm happy to, if we get to that point, to supplement that to the recordings at my exact hours for the trial preparation for Friday, and then the time here today, if that's all right.
I mean, just for the purposes of the record, so that everything's complete, shouldn't we have that number, before we conclude today?
I can get it for you.
All right, we'll work on that.
Okay.
And so putting a pin in that, we'll consider, with that one caveat, we'll consider the plaintiff's evidence closed and turn it back over to the defense.
Thank you.
Your Honor, and I know you didn't ask, but I've got no objection to letting him do his calculation and state those. I'll try to be efficient too, Your Honor. Having done this a number of times, I sort of just give you my spiel. As an officer of the court and counsel in this case, I'd like to state my place, the attorney's fees and expenses incurred in this action. That's pursuant to Nichols v. Main Street and Campbell v. Beek, which provide the opportunity to do that. I've reviewed the bills that have been issued to our client in this case, which I have here as Exhibit 10, which have been issued through September 4th, 2024. Your Honor, I'd move to admit Exhibit D10.
Any objection to D10?
No objection. Your
Admitted
Honor.
without objection.
With the other defense exhibits. Your Honor, I will further state that attorney's fees incurred by my client related to this matter have been since September 27th, 2022. This amount includes three things: my attorney time over the course of this litigation, billed at an hourly rate of $350 an hour. Prior to last night and today, my client had incurred 70.5 hours of my time addressing the plaintiff's claims and my client's counterclaim. Again, that total was $24,675. I'm going to add last night and today's time as well. There are 8.8 hours of associate time expended at a rate of $250 an hour, 6.7 hours of associate time at the rate of $275 an hour, and actually 1.1 hours of associate time expended at the rate of $300 an hour, for a total of associate time at $4,372. There's paralegal time expended at various rates, $150 and $135 an hour, due to the experience of those paralegals, 10.8 hours at $150 and 4.5 hours at $135. This time has been expended on legal research, taking depositions, exchanging written discovery, reviewing documents, and meeting with the client, and then preparation for this trial. Out-of-pocket costs and expenses incurred through September 4th, 2024 equals $1,254.84. As a result of all of this, Your Honor, I'm going to do some very quick and simple math. The attorney's fees since September 22nd, 2022, attorney's fees, including paralegal time, total $34,985. Out-of-pocket costs are $1,254. Based upon my experience practicing law in this area, including multiple trials for approximately 21 years, these fees and expenses are reasonable and were necessarily incurred given the issues raised in this case and the nature of the claims. That is all that I have, Your Honor.
All right. In terms of evidence as well?
Yes, Your Honor.
Okay. And again, for the record, is there any objection to the calculation of those attorney's fees on behalf of the defense?
No, Your Honor.
All right. And whenever you're ready again, just for completing the record, when you've got that final calculation on your own end, let's just tie that up.
Thank you. You want to do that now, or do you want to move on to?
Yeah, we can go ahead and do that now.
Okay, all right.
Yeah.
Could I have about 10 minutes?
Well, you know what? Maybe the best time to do that will be because I'll probably take a
Okay.
moment to kind of go back over my notes and everything. So that'd be the best time to do that.
Closing.
That's right.
Okay.
So I suppose the evidence now would be closed. And so if the parties want to kind of sum some things up, I think we've really been able to drill down on the core disputes. I'm really more focused at this point, and instead of kind of hearing again what we heard during opening, is how you think the law appropriately applies to the facts as you think they ought to be.
Right. Thank you, Your Honor, for the opportunity. I will try to do that, Your Honor. So on the legal points, there was a valid and binding exclusive exclusive agency and brokerage agreement pursuant to which Mr. Reynolds is entitled to get his commission. We've got that amount there. I think what the court wants me to really drill in on is the breach of contract issue here that we're dealing with. We believe that initially there was a contract, a purchase and sale agreement that was valid and binding as of September 5th, 2021, that the expiration date of that would have been October 15th, 2021, the date that it was supposed to close. Mr. Gazi requested an extension of that closing date and agreed to pay an additional $10,000 to extend the closing out. Contrary to defense counsel, I don't think that that is just some additional amount that might be due here. I think that is clearly part of the consideration for the agreement. The agreement specifically says for $10 and other good and valuable consideration, mutual benefits, things like that. The $10 was never paid. As I just established, there was no mutual benefit. This was all for the benefit of Mr. Gazi. He's the only one who wanted.
Well, so let me pause you there. So you think that the $10 itself would be sufficient to establish a breach of this amendment, or that the amendment had no legal effect?
Under Georgia law, I think it's both, Your Honor. I think that there's the $10 good and, valuable consideration. That was never paid. And then there's the earnest money aspect of it, and that's the
Well,
larger
let's set the
piece.
earnest money aside because it's that $10 that I'm kind of focusing on here. Because
Okay.
I just look at the language itself and it says now, therefore, in consideration of a sum of $10 paid by each other to the other, the receipt and sufficiency of which are hereby acknowledged. Under the terms of the contract as signed, weren't you saying, oh, I actually did get that $10?
Well, there's also a law, Your Honor, that says that the receipt and sufficiency of consideration can always be inquired into. And I think we've inquired into it today and established that it was never paid.
You have like a site where I could look into that?
I can get you one.
And the sufficiency of it, yes, we can inquire into it, but you're going beyond. It's kind of you're saying a question of fact as to whether it was actually paid. That's different than the evaluating the sufficiency, I would think.
Right, I think there are two prongs, receipt and sufficiency, both being acknowledged, but I believe that
But both parties signed it saying we did receive it.
I'll try to see if I can find the site for that,
Okay.
Your Honor, if I can. But again, I think the larger issue is the $10,000. And as I think Mr. Ghazi established, he testified, Mr. Reynolds testified, earnest money is a significant part of a real estate contract. And the $10,000, we believe, was never paid. I mean, with all due, respect, I understand what Mr. Deloach is saying about having the receipt and not having been able to get it to me earlier and things like that. But, it's just this one little thing that there's no context for it. I know we don't even have it in the evidence, I suppose, but I mean, it just seems highly unlikely to me that with the complaint being filed, with the answer being filed, with discovery, with depositions, that Mr. Ghazi never had that beforehand. So I would have to question the credibility of that document to the extent that it's been discussed here, that it's just something that never existed.
But I mean, even if he had sent it, wouldn't the way it was, I mean, would we apply like the mailbox rule where he's satisfied it just by putting it in the mail, or would it had to have been deposited? It says
It's supposed to be
deposited.
received.
So it really doesn't matter whether.
Exactly.
Okay.
Exactly. And again, I think that ultimately that, it was never received. It was never deposited. And so, and again, for him to have gone through this and say, well, I put it in the mail and I did all these things. Again, he knew how important that was because he'd paid it before by a wire. He didn't do that this time. So it was never received. It was never deposited. So my client nor the sellers ever got that extra $10,000. So as far as we're concerned, the original contract expired on October 15th. So he had no right to do anything beyond that. Then we go a few days later when they get back from Italy, and he sends this very, angry email copies Jean on this very angry email from his wife, how upset she is, that she's not upset with Jean. It's not Jean's fault, that she's upset with Bobby, that he didn't investigate this and tell her more about the property. That's all in her text to him. And then the very clear and what I believe is under the law anticipatory breach is that he sent that text that said, Sarah's pissed. We're going to have to walk away and forfeit the earnest money. And I do have a site for that, Your Honor, I found during lunch, or my colleague found during lunch. Legacy Academy versus Doles, Doles Smith, 344 Georgia Appeals, 805. The court said it's a question of fact whether a party engaged in conduct sufficient to give rise to a repudiation and anticipatory breach. Now, I know that it's defense counsel's position that you can't do that other than a formal notice through this contract, provided under the notice provisions of the contract. But I believe the court has already noted and already pointed out there are conduct, there's acts, there's conduct, there are other things that can act as an anticipatory breach. And I think that's exactly what Legacy Academy holds here. In the For What It's Worth department, I mean, I think that there are multiple ways that people breach contracts that give right to an action for breach of contract, anticipatory breach. And I've had multiple cases where people have had purchase and sale agreements. The buyer wants to go through the seller backs out, just doesn't show up. They don't send a formal termination letter, and yet we prevail on specific performance in those cases all the time. And I think that that law also applies here to show that you can breach a contract without a formal notice under this GAR, this Georgia Association of Realtors contract. So I think we've got a clear anticipatory breach there. And then I know they make quite a big deal of the fact that Mr. Reynolds really didn't do anything to reach out to try to see if they could still salvage this deal. But quite frankly, I don't think that he had any obligation to. You know, would it have been a nice thing to do? Could he have been polite and do something? Perhaps. But legally, once there's that anticipatory breach, I don't think he had any duty to formally respond back to Mr. Ghazi or to his attorney about any of these title issues that they brought up. And quite frankly, as he's testified today, as I said in my opening statement, I think those were purely pretext. They were just trying to manufacture a way to get out of losing their earnest money.
But, and I can agree with you completely there, but he did choose to respond, right? And so what's the best way you can tell me if through Defense Exhibit 9 that the email he responds back acknowledging the text is him still accepting a breach versus waiving it?
Well, I think that quite honestly, he's not a lawyer. You know, he's a real estate agent, and all due respect, he's got a high school degree. He's got a lot of experience, everything like that, but he's not a lawyer. In his mind, and based on this text, the contract was breached. That was anticipatory breach. And him reaching back out and saying, well, you know, you would have to pay the $10,000 that you've already deposited. He refers to the other $10,000. He tried to make it clear that that was never received. I think there was some indication they were trying to show that that indicated a receipt, which he says he didn't. So I don't think that you can try to parse his language to go back and say something that opens this back up to further negotiation. I mean, as far as Mr. Gazi was concerned, he was not going to buy that property. And frankly, you know, it wasn't even because of these title issues. It was because of what his wife told him about not wanting to live or not having property next to a gun range. We didn't hear any evidence that says she would have been okay to go through with this purchase. The whole reason for backing out apparently was that she didn't want to have this property. And he never testified here today that she was good with going through with the purchase. And if that's the real reason, we're back right to the breach. So at the end of the day, Your Honor, I believe it's very clear. The contract was not extended. There was no consideration, no additional earnest money. The contract expired October 15th. The text was an anticipatory breach. My client had no further obligation to do anything else. And based on that, that's why we filed this case and why we're asking for his commission and attorney's fees, which I'll supplement.
Settlement. Thank you.
Your Honor.
Thank you, Mr. Johnson. All right, Mr. Deloach. You think you could start off on that $10 issue? That's something I'm curious about.
I'm sorry, sir.
On the $10 consideration issue, do you have anything on point there? Because I mean, I've seen contracts
Actually,
that
I do. I'll go straight to that.
You know.
I think we don't even have to get to the $10, Your Honor. The case law is very clear. The amendment says, now therefore, for consideration, the sum of $10 and other valuable consideration paid by each to the other, the receipt and sufficiency of which are hereby acknowledged. So here's what's important, Your Honor. The $10, the case law says that and I don't have a cite, but I do have some statute and I do have some law for you. I do actually have a case. Is the $10 is just part of the consideration. The other valuable consideration paid by each to the other is mutual promises. And that is repeatedly found to be sufficient consideration under the law. In fact, Phillips Audio Video Systems v. Bateman, 160 Georgia Appeal 12, that's a 1981 case that I often use in request to charge, Your Honor. It says, when mutual promises are given, each promise is itself consideration for the return promise. In this case, there's a promise to extend the closing, mutual between the two of them. You don't have to look beyond that. That is a mutual promise that is sufficient under Georgia law. In fact, there's also a promise to pay earnest money. And I think the court is right on this point. Whether it actually got paid or not, in our opinion, does not affect the validity of the extension. And I want that point to be clear. The extension was not conditional on payment of the earnest money. In fact, it's quite the opposite. It says the earnest money is going to be paid 5 business days after the extension becomes effective.
So what would have been, in a hypothetical situation, a plaintiff's remedy for the breach of that term?
2 things, I think, Your Honor. 1, they have a right to sue for the earnest money. And it's actually not the plaintiffs, it's the sellers. And that's the point, is the seller's not the one trying to enforce this contract in this amendment. This is the broker. So the seller's remedies are different than the broker's remedies. And the seller had 2 remedies. The seller had a remedy to ask for and sue for the actual earnest money. And actually, the seller, this is where anticipatory breach actually could come in. And I'm going to get back to that with some case law. The seller may have had an argument that the failure to do so was an anticipatory breach, which would have excused the seller's further performance. And that would have come up in a case had Mr. Ghazi pursued a claim for specific performance. Anticipatory breach is, the court, I believe, will find, and I've searched, it is not a, this makes sense, not to be used as a shield. It's as a sword, it's a shield. Anticipatory breach gives a party a excuse for non-performance. And in fact, so I'll get to anticipatory breach, and I'm going to give you some case law on that. But have I answered your question with respect to the amendment? At least what our position is on the fact that there is valid consideration. The closing was extended until November 12th, we believe, because of valid consideration, the mutual exchange of promises. There's actually also, Your Honor, 13.342, consideration in a contract, defines that performance may consist of an act or other promise of forbearance or the creation, modification, or destruction of a legal relation. Well, in this case, it was a modification of the date of closing. So again, that is valid consideration under a contract, under 13.342, OCJ 13.342. Now, to go to the second, because I think we've got sort of relatively undisputed facts at this point, and in these legal issues that the court is applying to these facts. So one is the validity of the amendment. You asked about anticipatory repudiation. I'll tell the court, actually, that was never raised by the plaintiff in the complaint or at any point in time prior to this, and I think that's because what the law says about anticipatory repudiation is that idea that it excuses performance. I'll give the court a citation. I'm going to probably butcher the name. Shortery v. Fannin Regional Hospital. It's 317 Georgia Appeal 184. That case dealt with a contract, a physician contract, but it does a really good job, I think, in explaining anticipatory repudiation. It says the anticipatory repudiation of a contract occurs when one party thereto repudiates his contractual obligation to perform prior to the time such performance is required under the terms of the contract. Thus, when one party to a bilateral contract of mutual dependent promises absolutely refuses to perform and repudiates the contract prior to the time of his performance, the innocent party is at liberty to consider himself absolved from any future performance on his part. The breach, which will form the basis for an anticipatory breach of contract action, is an unqualified repudiation of the entire contract prior to the time for performance. I think there are 2 really important things when applying that law to this case. One is that text message on October 19th was not an unqualified, absolute refusal to perform. It indicates that an intent to walk away.
He says he wants to walk away.
He says he wants to walk away.
How do you get any less unqualified? I mean, what was left to be done if he's saying, I want to walk away, take my earnest money?
Your Honor, the hope was to work out a mutual termination of the agreement, which happens in real estate contracts all the time. So that is the initial indication of what he wants to do. But the court made a very important point. Exhibit 9, the letter back from the broker, shows that he understood that's what it was. Because he says, if you still want to terminate. So the broker understood what it was and says, if you want to terminate, these are the things that are going to happen. And that did not happen. He did not, Mr. Ghazi did not say yes. He didn't give an unqualified, absolutely, yes, I want to terminate. I want to do those things. That never happened. And the broker understood and told Mr. Ghazi what he needed to do. So I think those facts are really important, that 2 days later that happened. And the broker's language does tell you what he understood, I believe. That's the only evidence in the record. Now, the other thing that's important about the anticipatory repudiation, I'm going to say sort of law or doctrine, is that what it does is excuse the other party from performing. That meant if the seller were here, if this case was Mr. Ghazi seeking specific performance of this contract, then anticipatory repudiation would be a really relevant factual discussion for the court to determine. But in this scenario, this is not one where Mr. Ghazi is seeking specific performance against the seller. The seller is not here. This is not following any way that I have personally found anticipatory repudiation used before. This is a real estate broker suggesting that this email is sufficient for him to get his commission, not to excuse the seller's performance. And so I'll tell a couple other sites. Again, in looking at this, there's also Layer v. Clipper Petroleum, 319 Georgia Appeal 410. That's a 2012 case. The same thing that talks about anticipatory repudiation can excuse performance of the other party. And there's actually
It can do that.
I'm sorry, go ahead,
It
Your
can
Honor.
also set up a claim for breach. So a party can say, you've repudiated the contract, I don't have to perform, and you've caused me damages because you've breached it.
I think there is. Can I think of a factual scenario where that would be true? Yes, I can, Your Honor. I can. I think you're right. I think there is a scenario where for example, I think you gave one. If somebody totally disappeared and didn't do anything else.
But I guess you raised the point that a broker can't just on their own say, I am finding that the sellers don't have to perform anymore. I'm ripping the contract in half on their behalf. The seller would have to have some buy-in. Is that your point here?
That 100%. And in fact, Your Honor, you actually anticipated the next thing I have written down, which is the sellers did not terminate the contract. This is not a scenario where the sellers terminated the contract. This discussion would also look very differently if the seller had terminated the contract based on anticipatory repudiation. I think I would still have an argument that the facts don't support it, but I think the argument that it's not legally applicable would be harder for me. But here, where the seller did not terminate ever based on anticipatory repudiation, that is a very important fact. And so the court actually said it probably better than what I had written down, which is that the broker can't decide for the seller that they're just gonna, rip up the contract and throw it away. So, Your Honor, that addresses what I think is the second sort of legal issue from our perspective. And I think, I had one more case site, and this is just, this is actually one where a seller, it's Chowan v. Miller, 283 Georgia Appeal 749. 283 Georgia Appeal 749. That's actually a 2007 case where the court said the seller was entitled to terminate because of anticipatory repudiation, and that was actually a real estate deal. And it goes to the point that I don't want to belabor, but that it's up to the seller to terminate, and that did not happen in this case. Never happened. So then we get to the third sort of factual legal discussion, which which we believe is controlling. And that is, given that there was a valid extension, that closing was set for November 12th, the contract provides that there's an opportunity to present title objections that the seller can address. Those were presented, and not once. I mean, I know I went over and over, but unequivocally, there was zero response.
So then how would it have played out in a world where someone did present title objections just in an effort to try and escape the contract, and ones that
Absolutely.
didn't have merit, they would be
they
would be addressed, and then what?
Sure. I think the seller, if the seller, let's say, for example, the seller responded and said, we don't think these are valid title objections. We are not doing anything. You are obligated to close this contract. At that point in time, Mr. Ghazi then has a choice. He can either close the contract, which he testified he would have discussed with his counsel and may have done. So he was never given the opportunity to make that choice. Alternatively, he could have decided to stand on his title objections and say, no, I think they're valid title objections under the contract, and I'm not going to close. And then we might have had this dispute between the seller and Mr. Ghazi about whether the title objections are valid. But we don't even get to the issue about whether they're valid title objections because we have no response from the seller that gives him that choice that I just described. Because they might have come back and said, we don't think these are valid title objections, or we can't do anything about them. And then he would have had an opportunity to make a decision about whether to close. Frankly, he might have closed just to avoid being in this sort of dispute. He might have closed and tried to flip. He told you he would have made that decision, but he might have closed and tried to turn around and flip the property just so he didn't have to pay a commission for nothing and didn't have all of this. But they would not respond and never gave him that opportunity. And then he was left with, I mean, I've texted, I've called, my lawyers emailed letters twice. Nobody's getting back to us. They're not going to do anything. So I guess we'll terminate. And that's what happened. And for that reason, Your Honor, we believe that the plaintiff, the broker in this case, is not entitled to a commission because Mr. Gazi was not given the opportunity to close on this transaction.
All right. Thank you, Mr. Deloach.
Thank you.
Mr. Johnson, I think you're entitled to the last word.
Your Honor, just a couple of points on the legal issues that Mr. Deloach was discussing. The Shorty versus Fannin Hospital, Shorty, I probably wrote that down wrong, where he talks about when one party repudiates, the other is absolved from future performance. Well, although they're not a party to this case, the sellers were parties to the contract, and they were parties to all this communication that went out from Mr. Ghazi's attorney. So whether it was the sellers that didn't respond or Mr. Reynolds on their behalf as their agent, as Mr. Deloach just said, they were absolved from any future performance by Mr. Ghazi's anticipatory breach. So neither the sellers nor Mr. Reynolds as their agent had any reason to follow up with him about all these issues. So that's one on the anticipatory breach. And again, Your Honor, I think you hit it right on the head. I mean, I don't know what else could have been more unqualified than, you tie the statement from Mrs. Gazi, Sarah Gazi, about how upset she is. And that's included along with his text to Mr. Reynolds saying, Sarah's pissed, we're going to walk and forfeit the earnest money. I don't know how much more clear it could have been. He did not indicate anything in there. He could have said, Sarah's pissed, but let me talk with her and see if we can work something out. Let me talk with her. Nothing like that. It was just as clear cut and direct and firm as it could have been. We're done. She's mad. We can't buy this property. We're walking away. And in that regard, Your Honor, I think that is really what it's all about. And again, I'll say lastly, whatever else might have happened, we've heard no testimony, no evidence that she would have been okay to go ahead and buy this property. Thank you.
All right. Well, thank you, Mr. Johnson. So I want to take all the exhibits and my notes and take another look at everything. And, maybe 10, 15 minutes at least. And you think that's enough time to put
Yes, Your
together
Honor.
those numbers?
I appreciate
Okay.
indulgence and Mr. Deloach's professional that as well.
All right. Then let's just, we'll recess in place here and I hope to be back with you then.
Thank you.
Thanks for restrooms, Danny.
Okay.
Did you get a copy of those? Attorney's fees? Yeah, let's go back. And I'll go back. Conference room for a minute. What now?
Get out of here.
I usually did. It's like, we live in normal time now, so I'm just right there on the reds. File that way.
Happens that way sometimes.
Back to the other.
Yeah. Yes.
So what's the was talking about? I mean,
She-
out of money because.
Oh, yeah. Like they lost over $1 million.
Oh my gosh. And she's been tried or no? Has she in jail now?
She's out,
Oh, wow.
but she posted bond, she got bond, posted bond, she's out. Frankly, I'm sort of okay with it. Maybe after an election, we'll have a different attorney.
We
But
need more coffee signs around.
but yeah, I still can't figure out what's going on with her because the effort she took to fabricate all this stuff,
I know.
it's mind blowing,
Is she crazy? I mean, obviously.
clearly.
But
But what
what did she
happened-
do before this? Like, what was her job?
She
Are you gonna take her depo?
anybody can get her. I mean, they've subpoenaed her. I don't know what, I don't know that she'll show up. I don't know what, I mean, if she does, I think she'll have to take fifth on most of it
True.
because of criminal proceeding. But, they lost, so what, the way my clients lost so much money is this, based on these promises and, ended up being fraudulent. They spent all this money manufacturing product,
Okay.
buying all the stuff,
Right.
manufacturing product. And some of it got shipped places that were totally bogus. Some of it she stored in
Yeah,
a
so I'm thinking
warehouse.
she's Like, you're like, oh, what, Texas Children's Hospital? Oh, we got all this hand, where did this come
Yeah,
from?
well, guess
Why?
what? She actually just put it in some warehouse in Texas.
She didn't actually deliver. Oh my God.
There was all that problem with the delivery. She just found another warehouse to put it in. And then she had a warehouse with a bunch of stuff in Athens. And then so. It's
Did she get paid for anything?
not much.
That's
She didn't make
crazy.
much. She made. It is mind blowing. And then the argument. States the fact that sales. basically, let's tell this needle says, their argument is that their argument's gonna be that they got duped just like he did. And his argument is, well, you were responsible for her.
Right.
I relied on you. So at a minimum, you were negligent in the way you managed her. So that's the simple version of
Did
it.
they never like sold to anybody else after that, or it just like?
They were so
too big?
upside down in the, they'd spent all the money they had. It actually put their other little company out of business, Camilla's, which actually made a little bit of money, put them out of business too, because they didn't have enough to, they went all in their life, I mean, they had one in their life savings to put all that
Yeah.
money in.
Wow.
Cause the other company were throwing these $50 million numbers around. Have all these, you know, I mean, he's just a scientist. He's a doctor.
That's wild.
Yeah, it's a crazy.
Y'all gonna
He
get,
has an extra reason that he could.
Yeah, you're right. I'm gonna run to the restroom too.
cool.
That's why it's you know.
You gonna go to the restroom first?
Hopefully I'll get out of here before traffic.
Yeah. Fingers crossed.
Time's looking good.
Yeah.
It doesn't get too bad the other way, does it?
Oh, it's always bad.
Yeah, is it? Good thing you don't have to come down here too often.
Well, yeah, I mean, not retiring at all.
Yeah.
I mean, there's sort of that 10-year before I.
Yeah, yeah, yeah.
What I said, but it's just, because we were gonna redo the house, the roadway, so we just got like the figures to do all that.
Yeah.
Like, we're too old to be putting this much money in.
No.
So now I'm just like, we're so busy here.
Yeah,
This one,
yeah, right,
I'm
right.
super busy.
Yeah,
It doesn't
yeah.
make sense to, like, I keep thinking that I will get enough reporters that won't have to work.
Mhm.
And then there's just not enough reporters.
Yeah, yeah,
That hurts,
yeah,
so.
yeah.
I don't know if that's gonna. Cause I would like to read everything for all these years. But it's just, I was busy, so I think the plan
Yeah.
now is just to stay where we are.
Yeah, yeah. That's good. That's the worst place to be, you know?
I'm like, well, and I was like, well, we've always gonna have something happen. I'm
Yeah,
always gonna.
That's right.
Our family, my sister's here.
yeah,
I'm
yeah,
like, we're always gonna be
Right.
down at this place.
yeah, exactly.
Anyway, so for right now, we're staying put.
Yeah, yeah, we're good.
Yeah.
Call on you when needed then.
Mm-hmm.
It's done now.
Yes.
I can't picture it. I mean, yeah, but it came like.
Yeah.
Just before I forget it. You couldn't respond to.
Yeah, we could. See.
Youthful.
Yeah.
Anything else to say?
Yeah. Jeffrey, all getting up to looking at, let me see your son.
So we, let's see, before classes actually started, that he had his first race. So
Yeah.
we'd get up and
Yeah.
watch one race, and then we actually flew to Indianapolis. We were there less than 24 hours. He had a huge race at Terre Haute,
Yeah,
Indiana. So we saw him maybe 10 minutes.
Yeah.
Watching race.
yeah, yeah.
So, but Parents Weekend is not this weekend, but the next. So
Okay.
we
well,
should see him then.
Yeah, nice. Yeah, good.
But, yeah, I'm sure the second year, it service academy is a little different than the first, right?
It is, yeah, yeah, a lot more freedom, a lot more flexibility. He's on the water polo team and so it's kind of like for us to go see him play. We might see a couple of matches, but really hardly see him at all because he's got all the team
Sure.
stuff they've got to do.
That's exactly right.
Parents Weekend up at West Point is in, I guess it's about 2.5 weeks out. We get
Okay,
up there.
so, yeah.
Columbus Day weekend.
I think ours
We'll
is
go up there. See him.
the third, yeah, let's see, when is it? It's, yeah, we'll go to the 3rd of
Yeah.
October.
Yeah.
Is when we go.
Yeah.
So it'll be good. But,
Yeah.
but yeah, he's doing well. Just kind of like with any sport, you want him to stay healthy, so they keep doing
Mhm.
that.
Yeah.
And then
Yeah.
he's enjoying classes.
Yeah. good,
Um,
good.
so all seems to be good. Like, I mean, the guys on the team, all of that's been really good.
Mhm, mhm.
So
Yeah.
I've been thankful
Yeah.
for that.
Yeah, well, listen, I mean, I've known, I'm sure you have too, known several people that went there, and everybody just loves them,
That's,
I mean,
we've got
so-
nothing but that. I mean,
Yeah.
lots of positive,
Mhm.
yeah.
Yeah,
He's got one friend, or not friend, he's got one, I would say, acquaintance-ish, lives in the class ahead of him at Athens Academy, who's there, who
Okay, yeah.
is enjoying it. And then, but then a fair number of older kids.
Mhm,
Everybody had
mhm,
just
yeah.
great,
Yeah.
great things to say. So anyway, we all know West Point is, going to be a challenging but
Oh, yeah.
rewarding experience when he completes it, right?
Oh, yes, yes.
Last time you and I talked about it, he was still, he's still thinking sort of career, right?
Possibly, yeah, yeah. He's got a lot more interest in aviation here recently.
Oh,
They had
interesting.
What they call their branch week there a few weeks ago, where all the different armored and aviation all
Right.
bring their equipment and all the cool stuff, and have it set up on post, and he got to see. And so, of course, the Army flies almost exclusively helicopters,
Sure. The
But he's like,
Apaches. and-
Apache,
yeah.
Black Hawk. There's this one called the Little Bird, which he thinks it's like just a fast attack. And you go in, drop off some guys and take off, and he's like, yeah, that'd be cool. It's like, yeah, like mom and dad are going to be worried about you flying
I was
helicopters.
gonna say, that sounds great to
Attack
everybody but
helicopters.
your parents.
Yeah.
Oh, man.
Yeah.
Well, I know you're appropriately proud of him. You should be. It is, a special commitment
Yeah. Yeah.
to do that. I think I told you before, I grew up in Hinesville where Fort
Yeah.
Stewart is, so,
Mhm.
knew a fair number of,
Glen Academy.
no, I went to actually Hinesville's Liberty County. So
Oh,
Liberty,
Liberty.
yeah, yeah. But, a fair number of West Point grads. that,
Mhm. Come down there. Yeah. Yeah. He
Through
could
the
easily
years,
be
so-
stationed there,
Yeah.
it would be,
Yeah.
because they've got everything there.
They do. Oh, it's huge. It's the largest, military installation east of
East-
Mississippi.
Yeah, right, right.
So, that'll be good when he gets there, be a lot closer to home, obviously.
Mhm. Yeah, if he did that.
Yeah, and they do. It was always, so when I grew up, most of the time it was the 24th ID, which was primarily a heavy armored division. Then it became the 3rd ID.
Mhm,
It
mhm.
was actually, they were the 3rd it converted to the 3rd during Desert Storm, Desert Shield in like 1991.
Mhm.
And I think it's still largely heavy armored
Yeah,
division.
yeah.
There, but then you've got Hunter
Hunter Army Airfield is right
right
next
there
to them,
too. So
yeah,
they
yeah.
have all at Hunter.
Yeah. What'd you do in Air Force?
Security service.
Okay.
Not police, but like NSA
Okay,
kind of stuff.
yeah, nice.
That's what we did.
Yeah, yeah.
I was in Panama, El Salvador.
Okay. Central America, yeah, yeah.
To Germany a couple of times.
Mhm.
Stuff.
Yeah. Yeah. US has got a lot of bases in Germany. All the branches, Air Force and Army and all of them.
Always fascinated about talking about aviation.
Yeah.
So we lived in Germany and there's this base and if you look out across, it looked like a pasture, right? And then like the jets were running 21. This was all the world. I mean, nuclear bombs.
Really? Ready to go,
Yeah. They
Wow.
gave us these little radiation detectors. What's that gonna
Nuclear
do?
warhead on the jet, ready to go.
We were like,
Wow, that's kind of scary to think, that it was at that level.
so they
Yeah.
see what really went on.
Uh-huh.
Which the German, back then, the German, they didn't want us there because across the news.
Mm-hmm.
And
Mm-hmm.
then it was interesting.
Yeah.
Because it's just interesting just to look at what you think is a pasture. And then, you know, it's like.
Do they have like a cover kind of over
No,
of
it's
some
all
sort?
grass.
Okay.
Real grass.
Yeah, yeah.
And then the chips would be up underneath there
Uh-huh.
with the engine truck.
Wow.
I mean, what is it
So they
like?
could just go in,
Yeah.
just take off any time. Wow. That's crazy.
But we thought it was funny. They gave us those little radiation detectors. Oh, shit, man. I was right there.
Uh-huh.
It's like, what's it gonna do? Not like you can run.
Yeah, yeah. Why sit and wait for a jury to come back? You know?
See,
Yeah.
I couldn't sleep.
Yeah.
I mean, I fell asleep. I was like,
Mhm.
Sure, going on all week. No litigation.
It's,
Huh. Well, I mean, they've got a whole new GAR contract that came out recently, don't they? I've got a lawyer that I'm on kind of Facebook friends with, but you know, I mean, every day she's posting something kind of about this new provision, this new provision. I mean, there must be all kinds of.
Report once a week,
Yeah.
no.
twice a
it
month.
Varies. Yeah.
You got to sign with me, right? Just to.
It's all Clark County, huh?
Mm-mm.
All over.
Yeah, yeah.
I was in Oconee, I'll be in.
Doesn't it to sign, right? Yeah.
As far as here.
Oh, yeah, I mean, I've had cases in California.
Oh, really?
Yeah,
Oh, wow.
yeah, so, I got a case in Southern District, South
York?
Carolina right
Hmm.
now, so that's Charleston Division. Actually, it's the Charleston
Mhm.
District Court, South Carolina, there's only one district.
Yeah.
Yeah, I mean,
You must
so like
love
I've
it
gotta
then.
go. I mean,
Right. I mean, just never has gotten this far before, I guess. Never had anybody else.
yeah.
But never had anybody else.
of patents most of the time.
Yeah.
Because beyond that, it has to be a pretty substantial case
Sure.
for it to make sense.
But yeah, it is. It's crazy. It's like, like you should actually eat 10 hours.
Mhm.
You gotta be on access to house.
Have or are taking? Smart.
So fortunately, I've got more.
Mm-hmm,
Yeah. It's just like, but price haven't changed any.
mm-hmm.
Nothing changes.
Yeah, yeah.
Yeah.
A lot of times I can't fix it for them, right?
Mhm.
So then I just gotta minimize damage or try to help navigate out of this.
Soft landing.
Yeah, yeah.
Exactly. Try to navigate their way through it.
Uh-huh.
Days ago.
Uh-huh. Uh-huh, yeah, yeah. Uh-huh.
Glass.
Uh-huh, yeah.
Or two.
Okay.
I enjoy that too. It's about 20% of my practice and all, but just not volume, just people that are really hurt. They don't try their case. And
Please be seated, Bill. Please be seated.
Your Honor.
Yes, sir. Let's go back on the record.
Before I do have a further statement in my place as to my fees. So I have confirmed with our accounting department and based on the Exhibit 11, the total billed through April of this year, through April 2024, for attorney's fees and expenses to my client was $31,078.75. Over the course of the summer and getting ready for today, another $2,100. And then I just did today from 9 o'clock until 2:30 would come to $1,925 at 3:50 an hour. So the total that we would be asking for attorney's fees and expenses is $35,103.75.
All right. Any concerns or objections to the calculation of that number? Mr. Deloach?
None, Your Honor.
Okay. Anything else then, Mr. Johnson, we need to have as part of the record?
No, Your Honor.
All right. Thank you, Mr. Johnson. And first of all, thank you both for the presentation. Well argued and well presented and well prepared. And as with any opportunity I have to make findings of fact as the finder of fact, it's something I'm trying to take seriously and thank the parties for their trust and putting that determination in my hands. And so I did want to offer just some of my reactions and thought processes. So it's just not a naked ruling, but I'll throw in the caveat that once I get the proposed order back, I've reserved the right to clarify or amend any of these findings, and it's not a comprehensive kind of laying out of the law or where we are. So just a few things I just wanted to note here. And the first would be taking it step by step. When we look at the amendment, which was signed by both parties, it's one of the canons of contract law that we're supposed to construe it against the drafter. And so in this case, that would be Mr. Reynolds. So I look at the language of the amendment, and it does not appear that the escrow and the new term of the closing date is conditioned upon the payment of the escrow. So I do see that as its own independent term and condition based on a plain reading of it. And that leads us, the next question being, is this amendment breached by the defendant when that additional escrow is not received? And I think time of the essence is noted as an explicit term. The escrow is not deposited within 5 days. And so that would be a breach. Not every breach, though, requires an automatic remedy. There's a whole, an additional part of contract law we have to get through. So even if the 5 days, if that's a breach, the question is that I think that would also be a material breach potentially. But I don't think that's the end of the story here, which is, I think, by kind of considering the actions and the conduct of the parties and their course of interactions, that the timing of the performance of the payment of this escrow and whether that was going to be a breach canceling the contract entirely, I believe that was a waiver based on the email sent by Mr. Reynolds. I believe it was only a few days after the text message in the ensuing course of conduct, where the escrow is not raised, it's not mentioned, and essentially it's not demanded. And I think, again, my finding of fact there would be that there is an implied waiver essentially of that breach, and that in and of itself is not going to be enough to terminate the amendment. So then we turn to the arguments for anticipatory breach. And this is based on that text message. I think it was on October 19th, thereabouts, where in my read of that, the unqualified language is fairly absolute. It's saying, we have to walk away, take the escrow money, we're walking away. And walking away just on its face, regardless of how Mr. Reynolds interpreted it later, to me, I don't see a lot of wiggle room there. There's not a lot of daylight. Someone saying they're walking away doesn't really imply that they want to remain at the table negotiating the terms of their exit. But then that leads me to the exact same place I was before. Is this an anticipatory breach that was waived, or was it one that was essentially withdrawn? And my understanding of contract law is that a renunciation can be withdrawn as long as it's done before the other party is not injured in any way. And once it's withdrawn, the other party is bound to perform. And it's also something that has to be acted upon and recognized. And again, I come back to Defense Exhibit 9, where we have that email where it's quite explicit, where Mr. Reynolds is referring to the text and not referring to it in definitive terms. And I can recognize and sympathize with the fact that maybe he didn't understand the legal effect of those words, not being a lawyer. But in cases of contract, that's not something that we can excuse or overlook. And I think those words had a consequence here, where in the face of a absolute breach that essentially Mr. Ghazi was allowed to get back into the contract and to perform his obligations. And seeing as it went forward, it does appear to me that he did so, and that the lack of any communication from that point onward is not something I'm finding a legal excuse for. So with that, with those essentially those preliminary findings, I do believe that leads me to one conclusion, which is I don't think the plaintiff was able to meet their burden of proof on count one, and I think the defendants have been able to meet their burden on the counterclaims on both of those claims as they flow from the contract. And so I'd ask you, Mr. Deloach, for a proposed order on that, in whichever method or manner you want to present it. I'll take a look at it, and I'll have that on the docket. If that's something, I don't know if you can tell me if that's something you'd be able to have me, that proposed draft, by the end of the month.
Yes, Your Honor, that's very reasonable.
All right. Is there anything else further we need to have on the record on this matter, Mr. Johnson?
No, Your Honor.
All right, Mr. Deloach.
No, Your Honor.
All right. Thank you all again. We're off the record.
Thank you.
Thank you.
Thank you, Your Honor. What?
What does that mean?
Give me